the board. So first thing tonight is before we do any of the hearings, we have to do a very brief reorganization of the board. So for the board's benefit, we have to appoint a chair, a vice chair, the solicitor, appointment of the secretary, and then appointment of the conflict solicitor. So we'll just do these one at a time. So for the appointment of the chair, Pete had that job last year. Is there a nomination to have Pete keep that job?
Yeah, I nominate Pete to keep the job.
Can we have a second?
Second.
All in favor?
Aye.
All right. And then for vice chair, Dr. Van Wert had that position last year, I believe. Can we have a motion to reappoint Dr. Van Wert?
I'd like to nominate I'll nominate Dr. Van Wert.
Do we have a second on the nomination?
Second.
All in favor?
Aye.
Aye.
For third, the Fitzpatrick Lenson Buba, my law firm, serves in the role of solicitor. Is there a motion to reappoint Fitzpatrick Lenson Buba as solicitor?
Will you say yes?
Second.
I'm not pressuring you. It's,
No, yeah.
Kevin does a great job. It's
No, we're good. There's multiple words down there. So yes was easier.
Yep, there you go. All in favor?
Aye.
Aye.
For appointment of the secretary, David Taylor, the zoning officer, served in that role last year. Is there a motion to reappoint Dave?
Yes.
Is there a second?
Second.
All in favor?
Aye.
As for the conflict solicitor, the board typically appoints three because for various matters, given scheduling or other conflicts, we want to make sure that there's other people that are available. The three conflict solicitors last year and proposed are Kevin Kelleher, Matt Tranter, and Steve Strack. Can we have a motion to appoint those three as conflict solicitors?
Yes.
Second?
Second.
All in favor?
Aye.
Aye.
Now I'm going to step out because for the first matter that'll be heard tonight, I have a conflict.
Is this the one that?
No.
Oh.
Which one are we doing
We're going out
first?
of order.
We're doing number
Number 2 first. We're going to swap 2 and 1 around.
so 3.
Yes, 3. Yeah, I forget about the agenda.
Yeah, right.
I apologize.
No, you're
So we're
good.
doing Brighton Street.
Brighton.
We'll
Yeah.
do your normal announcement.
Yep.
Congratulations, everyone, and thank you.
All right. Congratulations too. I think. If you want to
It's a living.
still hang out with us
Sure.
on Wednesday evenings. All right. Welcome to the regular meeting of the City of Bethlehem Zoning Board. My name is Peter Schneck, and I'll be serving as chairman this evening. Serving along with me tonight is Paige Van Wert, Sharon Wiles Young, and Lucas Walk. Our zoning officer tonight. And tonight's secretary is Mr. Dave Taylor. Our solicitor tonight, our first one, our conflict solicitor, is attorney Kevin Kelleher. And later on this evening, it will be attorney Steve Boel. Our stenographer tonight is Ms. Moira Evans. At this time, if there's any members of the audience who have testimony, questions, and or comments, please stand and be sworn in.
For all items or just for one?
All items.
Right hand. Do you swear or affirm that the testimony which you shall give in the matter now before this board shall be the truth, the whole truth, and nothing but the truth? You do so swear or affirm?
I do.
All right. The first appeal tonight is 539 Brighton Street. Mr. Taylor, if you could read the facts of the case.
Is your microphone on? Or what are you asking?
Just not-
It's soft.
Um, 539 Brighton Street, appeal of David Ronca on behalf of Makata Partners, 539 Brighton LLC, for a variance from section 1306-01A footnote C, which restricts the maximum number of connected townhouses in the RG zoning district to a maximum of 4 connected, permitted, 6 connected proposed. Sections 1306.01A footnote C, 1325.06, and all associated variances, special exceptions, interpretations.
And before we get started, can you please advise when the property was posted?
It was posted January 20th. And I believe I provided photos to the city.
You did.
All right, with that, you can proceed with testimony.
Good evening. Victor Scamilio here on behalf of the applicant. And the request is pretty straightforward. This is in the RG district. It allows for townhomes, so the use is permitted. The question is the number of units that are in question here. The footnote reference is 4, and we have 6 proposed. We have the drawings that show the proposal. We also have overheads of the surrounding neighborhood. And with that, I will start my testimony with Mr. Ronca. Please state your name for the record.
David Ronca.
And Mr. Ronca, are you a principal owner of the entity that owns the real estate?
I am.
And what is the name of the owner of the real estate?
The owner is Makeda Partners, 539 Brighton, LLC.
Okay. Now, can you tell me about the lot, its dimensions, its size, its characteristics?
Yes, the lot is obviously located at 539 Brighton Street. There's an existing single-family home. The lot is, I believe, 100 and, forgive me, I think it's 100 and, going there. Yeah, 120 feet wide by, it's triangular in shape at the north end abutting Brighton. The east property line is 236 feet deep, and the west would be 179 feet deep.
And what do you, or strike that, let me ask you this question. Before coming here tonight, were you before the City of Bethlehem Planning Commission?
Yes, I was.
And at that meeting, was there anyone there to object to the requested development?
No.
And what was the outcome of that proceeding before the Planning Commission?
The Planning Commission viewed it favorably, believed it was in keeping with the area and other similar, I should say, other development that's going on within close proximity.
Now, let's talk about the area. Tell me about the surrounding neighborhood and what other buildings and facilities are in that area.
As you can see on the overhead, Mr. Taylor, if you could point to yeah, he's got the red dot is 530 is the existing property. Immediately to the west of it is a 6-unit. I'm not certain if they're townhomes or apartments, but they appear to be configured as townhomes. Then moving further west to the next building is another 6-unit. That is a 6-unit townhome development. Across the street is an 8-cluster townhome. And then moving up, I can't remember the name of the street, west and south is another, I believe that's another 8-cluster townhome. And then there are other ones within very close proximity. Yes, another one on, is that Cherokee Street? No.
Yes.
There it is, Cherokee. Yeah, that's Cherokee Street.
Okay, and do you have a description of what you're looking to build on this property? that
Yes.
Show the board,
Yes,
and was that in your application?
it is.
packet?
It is in the application package.
Would that be, you have the floor plans. Let's talk about the floor plans first.
Sure.
What are you looking to do by way of floor plans, dimensions, what have you?
They are 22-foot wide by 38-foot deep proposed 2-story units. They will have basement garages. However, the majority of the basement is below grade, if you will. So they are from the front, they'll appear to be 3 stories, but they are in fact 2-story with basement garages. And you can see that when Mr. Taylor scrolls to the elevations.
If we could stop there, Mr. Taylor. This is what you are looking to put the front Brighton Street.
No, that'll front, this will be west facing.
Okay.
If Mr. Taylor scrolls up, you'll see the west, I'm sorry, the north side that will be facing Brighton. And there are some changes that are going to be made that we've discussed with the planning director
Okay.
to have it appear more. And I actually believe that may be an older version of it. I'm not
Why don't you
100%
tell
sure.
for the board what you're looking to have the facade of the buildings look like? And
They will be a combination of masonry and you can see the standing seam metal roofs on the porticos at the entrances. There'll be mid-level entry units where you'll walk up to an intermediate level, which will give you the ability to walk. You'll enter into a landing with a walk down to the garage area, walk up to the half-story, walk up to the living space area.
and so this is essentially what you're looking to do in the neighborhood or on that property?
That's correct.
And how does that style fit into the other 6 or more unit townhomes in that?
I believe it to be very much in keeping. They're all, in fact, there are similar split units on, again, forgive me, I can't remember the name of the street, within a block or so of these. The ones that the sixplex that's facing Brighton, exactly right where Mr. Taylor's about to drop the street viewer, is similar. However, these are lower level entries. But again, it is a 6 unit, as well as the one, if he moves a little bit east. Now these have 3 entering from the rear, and I believe 3 entering from the south side.
And tell me about in the RG district, you could put a 6-unit MDU,
Yes.
dwelling unit apartment building on that property.
That is correct. We meet the requirements for 6. The density would allow for 6 units, as well as a building of the same size, configuration, footprint area, if you will.
And so tell me why the request for the townhomes versus the MDU.
I think the townhomes are more in keeping with the neighborhood.
And the development of the lot structure itself, it's not a uniform lot. In other words, it's not.
It is not.
rectangle
No.
or-
No, with the triangular, you've got a triangular, the north side of the lot is triangular in shape, as you can see on the site plan. As well, the lot slopes, it does have a relatively significant elevation rise to where the basement floor level will be. And as you move further south, there is a more significant increase in slope. And obviously, the more we encroach into that area, the more severe of a slope we'll create. So in my opinion, it's best to keep the units clustered all as a 6 cluster, as opposed to splitting them up to a 4-2 or a 3-3 or whatever
So
other combination.
to follow up on what you just said, if you were to split these into either a 4-unit and a 2-unit or a 3 and 3, it would you would be hampered by the slope of the
Exactly.
property.
Exactly.
And would it also impact the amount of setback and green area that would be left open?
It would to the south side. That was part of my objective as well, is to keep as much of that, to keep that slope as lessened as possible, and as well keep it as the open space area of the lot, the majority of the open space area of the lot, which is that area, as contiguous as possible, as opposed to interrupting it or encroaching further into it.
And you submit that this is the variance you need from going from 4 to 6 units is the least amount of variance you need for this.
Well, it's going from as opposed to splitting it up into 4 and 2. Yes, yes, exactly.
To have the 6-unit is better use of the land for spacing and the topography fits the the 6-unit rather than splitting it up into multiple
Exactly.
dwellings. That's all we have by way of record.
Questions from the board?
May I ask a question? Yeah. Mr. Ronco, when you appeared before the City Planning Commission, you talked about their reception to your plan. Was there any formal action taken by the Planning Commission?
There was not.
So what was,
And
what
this,
was your purpose, or maybe you or council can answer, what was the purpose then of appearing before them?
it was a sketch submission
Very well.
to get their feedback.
I don't have a zoning map in front of me. So are all of those townhomes that you compared this proposal to in the RG area?
It's a great question. I forgot to ask.
They are. Actually, that was formerly an RT zone, I believe. But yes, they
So I'm
are.
just trying to figure out how they got built. Were they built before
Oh
2012?
yeah, most of those are predate the
They
2012.
predate the current zoning
Exactly,
regulations.
yeah.
And you testify that you could build the same thing in a unit dwelling by right, but you're deciding not to. So are there like ADA requirements for these? Because none of them are wheelchair friendly.
There would not be
There's no requirement.
for
to-
townhomes. There's no requirement for ADA.
Okay. And I don't see where the curb cut would be to go in.
The
for-
curb cut is almost where the existing one is, which is if you, Mr. Taylor moves up a little bit further, or moves a little bit further east if he can. Right, yeah. Yes, unfortunately, I think that is the existing curb cut that you're looking at now, and it's going to be very close to that, with the exception of it being widened to about 24 feet. Now, the existing west side of it would probably stay where it's at. The opening would widen further to the east. Exactly.
And there's some large trees on your property. Have you done a survey of what trees would need to be lost to accommodate this?
The trees, I don't think there's any significant large trees on the lot.
Okay. I'm seeing.
Yeah, those are right at the edge of the property. The property ends right about where that, if you see that, exactly.
That's a
Where
slope.
Yes.
Yeah.
Yeah.
Okay.
So I just have one question with the elevation changes and with the proposed townhomes. Are they taller because of the parking in the ground than the surrounding townhomes?
Not necessarily. From the west side, they appear that way. The west elevation, the front elevation. However, all the remaining, the east facing elevation would appear at 2 stories, obviously, as well as the majority of the south elevation. The north elevation will appear close to 2.5 stories.
Do you have a rear elevation?
I do not, but it will be identical to what, actually, I don't. I apologize. No.
But there's no egress
east
from the
up.
back.
Yes,
of-
there's
There is?
there's patio. There'll be patios at that elevation.
Okay.
Yeah, there'll be walkout patios at the east elevation.
Okay. That's all my questions.
My one question, you're only asking for a variance for the number of units, but the way I read footnote C, it's dwelling units may be in RG district, a maximum of 4 single-family attached townhouse dwelling units may be attached in any row or grouping and shall not exceed a total combined building length of 120 feet.
Correct.
So each one of your units are 22
22,
and you have 6.
6.
So I believe that I'm doing the math correctly.
We have 100. You mean the total length of the building?
32.
Is
So
that what
do
you're
you
referring
need
to?
a
The total
dimensional
length is
value?
100 but that does that that applies to,
That
That's
applies to the 4.
to the 4.
Yeah, I think it all, I understand where what your question is. When that's if you do the 4, if you did 4, they would be maxed out at 30 feet per unit. for
Right.
4. So that's where that variance is for this. When you go to the 6 by natural order, it would.
I mean, I'm cool with what I just want to make sure that they don't have to come back for.
I hear what Mr. Scamilio is saying. And to be honest, it could have been an oversight on the review process. Exactly. It would probably be safer if the board was amenable to amending, if the board felt so inclined.
If it makes the record clear, then we would ask for that amendment to.
Yes.
Would it be 132 feet? Is my math?
What's 22 times 6? So yes.
132.
So it's 132.
Do we have
Not bad for
a
a pop-up
dimensional
sign major.
length? Because you said you were already with the apartments, like you can already put 6 there, right? So
That is correct.
can we look at that? Like, is there somewhere to look at that?
Right. I mean, he's meeting all the other like setback requirements. I believe there's no other dimensional issues that you found.
There were no other dimensional issues. It was just per the review. I mean, other than the building length, which I think is a valid point to bring up. Per my review of it, it was a matter of he could put 2 3-unit buildings there.
Mhm.
It was just a matter of bringing the 3 together to make 6 of
So
them.
you don't need a variance for if we do, we're just kind of switching. Okay. All right. Thank
So,
you.
Mr. Scamilio, your argument would be that if these were 2 buildings with 3 units each one of those could be 120 feet maximum.
Correct.
That is correct.
They could each be 120, and then, like Mr. Ronca said, it would then impact, because it would have to be separation between the buildings. It would be different configuration of land that would not only get into topography, but would take away into more of the setback and dimensional area. So this is we submit a better fit to the lot.
But to the extent it may be necessary, if these 6 units would add up to a total width of 132 feet, and it's found there to be a maximum allowable width of 120 feet, you're asking for that variance as well.
Yes.
We understand. Thank you.
Any other questions? Anybody in the audience? All right, any closing statements?
Just that this board is well familiar with the standards for a variance. When you look at the topography of the land, its shape, that presents conditions that make this use more favorable and appropriate for this property. It also makes it appropriate in the context of the surrounding neighborhood, as it is almost literally surrounded by similar structures. And the townhome versus the multi-dwelling unit becomes an interesting discussion. He could put an MDU here that meets or exceeds this spacing or this footprint for this building. We submit the request to go from 4 to 6 units is a reasonable request and the minimum needed to comply with the zoning ordinance.
And to clarify, the length that Mr. Schneck brought up would not apply in that instance.
Right, the one, yeah. If we did the MDU, we wouldn't have that issue.
All right. At this
And before we close the record, do you move for the admission of the exhibits that are attached to your application?
We do.
They're
Yes.
accepted.
Yeah, as well as the overhead that was in red that was submitted to Mr. Taylor this week.
And are they all collectively applicant's exhibit number 1?
Yes.
All right, they'll be marked that way.
All right. At this time, we'll go off the record.
And we'll close the record.
Okey-doke.
All right. At this time, we'll go back on the record. If I can have a motion from a member of the board.
Sure. I would like to approve make a motion to approve the two variances, the one variance for the number of units and the other variance for the dimensional width.
Second.
Mr. Schneck,
Yes.
Dr. Van Wert,
Yes.
Ms. Wiles Young,
Yes.
and Mr. Wolf.
Yes.
Motion carries 4-0.
All right.
Thank you very much.
Appreciate your time.
Thank you all. Enjoy the rest of your evening.
All right.
Good to see you all again.
You too. Happy New Year. Belated.
I'll be back sooner or later.
Yes, thank you.
Dave.
Thank you as always.
Thanks, Warren.
All right.
So now we'll go to
All right. The next
Yeah.
appeal
So,
is
yeah.
436 First Terrace.
436 First Terrace, the appeal of Austin Saboni on behalf of 436 First Terrace LLC for an interpretation that subject property retains a vested non-conforming student housing use. Alternatively, if the board determines the non-conforming status has lapsed, applicant seeks a variance to permit student housing use outside of the student housing and student home overlay zoning district. Applicant further requests a special exception approval to expand a non-conforming student home in order to accommodate 5 total students. Expansion of a lawful non-conforming use requires a special exception for expansions greater than 5% and up to a maximum of 50% of the total floor area measured in aggregate over the entire life of the nonconformity. 492 square feet permitted, 328 square feet is proposed. Sections 1302.48, 1302.131, 1323.03, 1323.04, 1323.06, 1325.05, 1325.06, 1325.07, and 1327.01C, and all associated variances, special exceptions, and interpretations.
All right. And before we get officially started, can you please advise when the property was posted?
Property was posted on January 16th, 2026. Before we proceed, can I just confirm that the application includes the letter dated October 15th from the zoning officer, with which is the interpretation being appealed?
Give us 1 second. We'll confirm that.
I believe it was included.
I remember saying that. I didn't know if it was within the application.
I think it's October 14th.
14th, correct. Sorry, the hearing was supposed to be October 15th.
You're close. I don't see it in there, Dave. No, that is not currently attached to the application.
Copies of it, 4 minutes.
I have one copy, but I
have copies.
You have you have it within
I have
yours?
lots of copies.
okay. Are you introducing it as a city exhibit then?
If you'd like, I can do that.
Because I thought it was included, but I just want to make sure before we can.
I understand. It would be appropriate to include it, so I can mark it.
I noticed it wasn't on the website when it was posted, so I just want to make
No,
sure.
no, we appreciate the question since that's the determination being appealed from. It sounds like they'll introduce it. It'll be in the record. We appreciate that clarification and we'll make sure that it's in for consideration.
Okay.
I apologize.
No, I just want to make sure because it should have been. I just
No, we want to
before.
be in record. So one other housekeeping item. So we have an even number of board members, but even beforehand, we learned that there will be a recusal of a board member. So Dr. Van Wert, are you recusing from this matter?
Yep.
All right, so Doctor, that means you can't participate in questioning, deliberations, or anything like that.
Okay.
Do you mind if she sits up here rather than?
No,
sit on
it's
there?
fine.
Yeah.
Will she be acting as an alternate or
No,
no? Just
she's,
all right.
no, She's recusing. Okay, all right.
No problem. Just please note my appearance, Matthew Deschler for the city.
Okay. All right, now we got that. Go ahead.
Dave, if you want to read the facts of the case.
He did.
Oh, you did?
Yeah.
Oh, you proceeded.
I guess the question is, should the facts of the case include the interpretation? That's my.
So the matter tonight is an appeal from an interpretation of the zoning officer. Usually when we read the facts of the case, it is simply the notice that is read into the, that's read into the record. I think what Attorney Raschudi's asking is, since the interpretation is the basis of the entire matter, should that be read into the very beginning of it? If you have the copy, we can certainly read that in. I think that would be prudent.
The October 14th letter?
Yes, do you have it?
I do have it in front of me, yeah.
Do you want to read that in the record for the board?
I have a lot of exhibits, so when I mark this, this will be city exhibit 26.
There's a lot of numbers, Matt.
Yes.
All right. All right, so Dave, please read that in the record.
Okay, it was my letter of October 14th, 2025 to Attorney Raschuti. Since my last review comments regarding 536 First Terrace generated on June 16th, 2025, I've become aware that the dwelling unit has not been utilized or occupied in excess of 2 years. Neither has it maintained a current license and successfully passed an annual inspection under Article 1739 of the zoning ordinance, so as to maintain, and actually the letter does not contain of the zoning ordinance. It's section Article 1739, so as to maintain any non-conforming status as a student housing use outside of the CB, CL, IR-R, or SH overlay districts. See zoning ordinance section 1327.01C. Given this new information, I am obligated to consider the full language of the above referenced section along with the requirements of zoning ordinance 1323.06B and C. A non-conforming use, building or structure discontinued for a period of 12 consecutive months shall be presumed abandoned and shall not thereafter be revived without proof satisfactory to the zoning officer that the owner did not intend its abandonment through disuse. Failure to market a vacant property for sale or lease for a period of 12 months will result in abandonment and evidence of intent to discontinue and abandon a non-conforming use, building, or structure. Taking into account the property's inability to pass the required inspection and the lack of utilization as a student housing unit, I am obligated to revise my previous position that the dwelling is legally non-conforming. My position is that any nonconformity that may have existed was never properly established and has since been abandoned. The city, therefore, intends to appear at the zoning hearing scheduled for October 15th, 2025, and oppose the special exception requested by your client on the basis that your client cannot meet the specific objective criteria for the expansion of the nonconforming use under zoning ordinance section 1323.04 because the use is not nonconforming. It is the city's position that a variance is required to utilize the subject property for student housing. Should your client wish to amend its application to request a variance, it may do so without payment of any additional fees. If your client wishes to amend its application, then he will need to continue the hearing and execute the necessary MPC waiver so that the hearing may be advertised to include the variance request. Should you have any questions, please do not hesitate to contact me. Kind regards, David W. Taylor.
Thank you. Okay. And just for clarification for the record, an amended application was filed, and that's what we're here on tonight. Okay. All right. Going to pass out my.
Would you like me to pass up the appeal letter? I can wait.
We haven't marked it, so I think we're going to use it as an exhibit within your packet.
Sure.
Yep.
All right.
All right, Attorney Rashidi, the
All
floor
right.
is yours.
Thank you. You were not sworn in, so he got here late. I
Please.
just want to make sure he gets sworn
Yeah,
in.
anyone else that's in the room relative to this matter, or any other matters tonight that was not sworn in? If you're sworn in before, don't worry about it, but please rise and be sworn.
Raise your right hands. Do you swear or affirm that the testimony which you shall give in the matter now before this board shall be the truth, the whole truth, and nothing but the truth? Do you so swear or affirm?
Yes.
Thank you.
All right, thank you. All right. Dimitri, can you just state and spell your first and last name for the record?
My name is Dimitro, last name Glignani.
Yeah, can you pull the mic towards you?
Close.
First name Dimitro, it's D as in David, M as in Mary, Y, T as in Tom, R as in Ronald, O, and last name is Glignani, G as in Gold, L as in Larry, Y, N as in Nancy, Y, A, N as in Nancy, Y, Y.
Thank you. And what is your relationship to 436 First Terrace LLC?
I am a member of Lehigh Properties GP LLC, an entity that solely owns 436 First Terrace LLC.
Okay. And when did Lehigh Properties first purchase 436 First Terrace?
It was purchased in August of 2019. Our intention was always to convert it to a student housing property after the owner moving out.
And looking at the exhibit packet in front of you, is the deed to that property exhibit marked as Exhibit 1?
Correct.
Okay. And you purchased it in August of 2019?
Correct.
Okay. Who was living in the property when you acquired it?
Kathleen was the prior owner.
And did she remain in the property after purchase?
Yes, she did.
Okay. And looking at Exhibit 2, we'll call it A2, A1?
Sure.
That's fine. Is that the lease agreement with Kathleen?
That's correct.
And what was Kathleen's relationship to the property?
Her family owned the property for a long time, and at the time of the sale, she was occupying it.
Okay. And for how long did she occupy it after the sale?
After the sale, she resided in the property for a number of years until she passed away in 2024.
Okay. Was that the original intent for her to stay in that property for that long?
No, the intent was to convert it to a student housing property, but given circumstances, her financial position and her health condition, we didn't think it was the right thing to pursue action against her, so we let her stay at the property.
Okay. And what was her health condition?
She unfortunately was diagnosed with cancer, and she also had issues with her heart. I believe she had congested heart failure.
Okay. And looking at Exhibit 2, the lease, can you just look at the dates that start on that lease? It's under number 3 on the front page, just to help you out. And when does that, what is that date?
So the lease started on August 30th of 2019, and it was supposed to end on February 28th of 2020.
Okay. Thank you. Now, when you purchased the property, did you register it with the city as a regulated rental unit?
We did.
Okay. And was a student housing use permitted for that property under the zoning code when you bought it?
Yes.
And just to clarify that for the record, student housing was not a defined term in the zoning ordinance at that time, was it?
It was not.
Okay. And you could have up to 5 unrelated people in the property at that time.
That's correct.
So looking at Exhibit 3, and just to clarify, you're familiar with the emails and we're copied on emails between your partner, Mr. Saboni, and the city, and you've reviewed these emails before?
Correct. I am his business partner, and I'm actively involved in all the matters related to the student housing portfolio. And just for context, Austin was not able to attend given his wife gave birth on Monday. So I had to substitute.
Okay. And looking at Exhibit 3, can you just
Yeah.
What is the date of that email?
It's January 8th, 2020.
Okay. And is 436 First Terrace listed as a property that needed inspection?
It is.
Okay. And that email's with Marion Hugh of the City of Bethlehem, correct?
That's correct.
All right. Now, looking at Exhibit 4, is this another email between Mr. Saboni and Marion Hugh regarding the inspection of 436 First Terrace?
That's correct.
And what is the date of that email?
March 11th, 2020.
All right. And going back into that email, if you turn the second page of that chain, looking at the March 9th, 2020 email, is there a fee listed for inspections?
Correct. There is a fee.
Okay. And were those fees paid?
Yes, they were.
Now, looking at Exhibit 5, these are receipts that you have, correct?
Yes.
And there's several here, and they're related to the permit for the HRRU zone. Is that correct?
That's correct.
Or, sorry, HRRU inspection. Clarify that for the record. And what does RRU stand for?
Rental regulated unit.
We just clarified, it's
Regulated.
regulated rental units.
I was going to clarify.
Sorry.
All right. And these are receipts showing payments made for, can you just read the years on there?
Yes. So the payment was made on April 11th of 2024.
And then the second page?
June 14th of 2023.
Okay. And then I think there's a fourth.
Yeah. May 11th of 2023. And then the last one was for August 13th of 2021.
Okay. Now, these are all documents you provided to me, correct?
That's correct.
All right. Now, looking at Exhibit 6 in front of you, can you just describe that for the board?
Yes. So we've been trying to schedule inspection, but unfortunately, I guess we weren't able to do so.
And who are those emails with? Can you just explain?
That was Nicole Irvin, rental housing and zoning assistant.
And then there was another email regarding below that one.
Yes, that was communication with Mike Simonson.
Okay. And these are all emails regarding the RRU inspection, correct?
That's correct.
And what date are these from?
May 17th of 2023.
Okay. Now, looking at Exhibit 7. What can you just describe this email and what it's regarding and what the date is of it?
Yes, so the email was from May 16th of 2023. It was to Philip Broder, and it was with regards to scheduling inspection.
Okay. And is 436 First Terrace one of the properties scheduled for inspection on that email?
Correct.
Okay. Now, you stated you've made payment. Has the city ever refused your payment for a regulated rental unit inspection?
No.
Did they conduct inspections for those properties?
They did, but the city did several RU inspections. Unfortunately, it was a little bit challenging to get access to the property because Kathleen, the owner, the prior owner who was occupying it, was very concerned about her health, and she wasn't willing to provide access to the property.
Okay. Now, there was an inspection done in 2022. Is that correct?
That's correct.
All right. Looking at Exhibit 8, is that the inspection report from that?
That's correct.
Okay. And that's for 436 First Terrace, correct?
That's correct.
Okay. Without getting into too much detail about what this exhibit shows, did it pass inspection at that time?
It did not.
Okay. And there was a lot of work to be done, correct?
That's correct.
All right. Now, did the city ever cite 436 First Terrace for violations of the regulated rental unit ordinance?
Yes.
Okay. And you actually, judgments were imposed, is that correct?
That's correct.
So looking at Exhibit 9 in front of you, is that one of the one of the judgments?
That's correct.
And what date is that from?
That's from August 20th of 2024.
Date of the judgment.
Apologies. January 24th of 2025.
Okay. And you paid the fine and everything in that case?
We did.
Okay. Now looking at Exhibit 10, is that another judgment imposed for violation of, or order imposing sentence for violation of the regulated rental ordinance?
That's correct.
And what is the date of that one?
July 30th, 2025.
Okay. And you paid that fine?
We did.
Since the property has been purchased by you, did you attempt to market the property to students for rental?
Yes, it has been on our website since the time of the acquisition, and we've actually had conversations with several prospective student tenants.
Okay. And some of those were email conversations, correct?
That's correct.
So looking at Exhibit 11, is that an email between your company and a prospective tenant?
That's correct.
And is 436 First Terrace one of the properties that is listed as a prospective unit for a student rental?
Correct.
Okay, and what is the date of that email?
October 5th of 2021.
Okay. And if you go page through that, there's several. Are these photographs of that unit?
Yes, some of the photographs are of 436 First Terrace.
Now looking at Exhibit 12, is this another email communication between your company and a prospective student renter?
Correct.
Okay. And was 436 First Terrace one of the properties that was offered to rent to them?
That's correct.
Okay. And what was the date of that email?
October 7th of 2021.
Okay. Now looking at Exhibit 13, is this another chain of emails between a prospective student tenant and your company?
That's correct.
And was 436 First Terrace one of the prospective rental properties offered to them?
It was one of the properties offered.
Okay.
Hey, Mike, I'm sorry. I have two Exhibit 12s.
I apologize.
You know what? I think they're just duplicates. I think it's the exact same thing.
My packet does not have two 12s.
You know what? No, wait, don't.
Could be just a second email of the same.
No, I think it's just the same exhibit twice for me. So I think you're good.
This copied. I'll get you one. I have an extra packet here. All right. So looking at Exhibit 14, is that another email between a prospective tenant and your company?
That's correct.
And at that point, was 436 First Terrace one of the properties he was interested in?
Yes, it was.
And what is the date of that email?
June 24th of 2021.
Okay. prior to October 14th, 2025, did the city ever notify you that student rental use was not a lawful use at the property?
No,
Okay. Has anyone from the city ever told you that the property was not classified as a regulated rental unit?
no,
Did you rely on the city's continued acceptance of licensing fees and maintaining the property as a student rental?
no. Yes, we did. Sorry.
Just clarify that. So you relied on the city's continuous licensing fees and maintaining the property as a student rental?
Yes, we did.
Okay. Did you rely on the fact that the city had conducted inspections of the property in determining whether that was a student housing rental that you could market as a student housing rental?
Yes, we did.
And when the city fined you and took you to court, was that because you violated the regulated rental unit ordinance?
No,
So when they took you to court, that wasn't for a violation of the regulated rental unit?
no, apologies. It was.
Okay, let me just clarify. All right. Did you also, going to look at Exhibit 15 here. You have that in front of you. So there's an email from Melissa Sillo at tfgtax.com regarding a business license fee for 2020 and 2021. Did you register that property as a business with the city of Bethlehem as a rental property?
We did.
Okay. And that email just says that the fee for 2020 was moved to 2021. Is that correct?
That's correct.
All right. Now, you previously testified here today that the property was marketed to students. Can you explain any period, and you may have done this already, but can you explain any period when the home was not occupied by students and why it wasn't occupied by students?
Kathleen, the original owner, was residing at the property, and we were not able to, I guess, give access to prospective students because she would deny entry. Given her health condition, she was very concerned about her health, and also she was in a bad financial situation, so we felt it was not the right thing to do to pursue any action to evict her from the property.
So you didn't take any action to evict her because she was sick and didn't have the financial means, correct?
That's correct.
Did you charge her rent at all?
No,
You never charged her a dime of rent, correct?
no,
While the property was occupied, did you maintain utilities, insurance, and property taxes on the property?
we did.
And those were always paid?
Yes,
Now, have you done any improvements or renovations to the property since it's been vacant?
we started demolition, but nothing beyond that.
Did you ever put in a solar system in the property?
We did.
Okay, that was early on when you bought it?
That's correct.
Okay. But other than that, you haven't done any other renovations to the property?
That's correct.
And has the zoning and the pending zoning case delayed any permits being issued to you?
Yes,
Okay. Did you ever intend not to use the home as student housing?
no, we always intended to use it as student housing.
Okay. And at any time, did you intend to abandon the student rental use?
No,
And to clarify, you believed you had a student housing rental use for that property, correct?
yes, we did.
What steps did you take to preserve and expand your student housing use?
We try to bring the property up to code and comply with inspections that we paid for each year, and we look to expand the use essentially.
Okay. And Just to clarify for the record, there were circumstances such as your tenant's illness and the pandemic that caused some delays.
That's correct.
After the tenant vacated the property, and the property was previously marketed to students, did you obtain any feedback from prospective student renters about the condition of the property?
Yes, we had several interested students, and they expressed that they would love to live in a newly renovated property.
Okay. And the regulated rental inspections indicated repairs were necessary at the property?
Yes.
Um, And were the repairs necessary to make the property compliant for student rental use?
The property was entirely in disrepair. There were lots of fixes that were needed to be done to the property to make it habitable again.
Okay. Now, the feedback you got regarding the property from student renters led you to have some plans drawn up, correct?
Yes.
And that was for a proposed expansion of the property?
Yes.
And this expansion was ostensibly permitted by special exception, correct?
Yes.
And just to clarify, it was only the day before the scheduled hearing on this matter in October that the city first notified you that the property was not a student rental or that use was abandoned. Is that correct?
Yes.
Okay. And as a result, you filed the amended appeal, which is the subject of tonight's hearing.
Yes.
Okay. Let's just talk a little bit about the proposed expansion, just so I can get it on the record now. Describe the improvements you plan to make at the property.
The project entails the demolition of the existing roof and attic and addition essentially of a second level. And as part of that addition, there will be 3 new bedrooms and 2 bathrooms added to the property for a total of 5 bedrooms and 3 bathrooms.
Okay. And just for the board's sake, Gary Later, the architect, is here. He'll testify regarding the specifics of the plan and the parking, but we'll just go over it a little bit here. How will this addition improve safety and habitability of the property?
This addition will subject the property to the new building code, and it will be a safer end product for the property residents.
Okay. How many off-street parking spaces will be available once the property renovations would be complete?
3 parking spaces will be available.
Off-street?
Off-street.
Okay. Will there be any increase in occupancy or dwelling units?
Yes, it will be going from 3 bedrooms to 5 bedrooms, but there will be no increase to dwelling units.
Okay. Do you believe that the expansion would be consistent with the city's comprehensive plan and consistent with the spirit, purpose, and intent of this zoning ordinance?
Yes, we are working with the rules that are set forth.
Okay. And that's for the expansion of a non-conforming use?
Yes.
Okay. Is the expansion in the best interest of Bethlehem, the convenience of the community, the public welfare, and would it be a substantial improvement to the property in the immediate vicinity?
Yes, we believe so.
Is the expansion suitable for the property in question and designed, constructed, operated, and maintained so as to be in harmony with the appropriate and inappropriate in appearance with the existing or intended character of the general vicinity?
Yes.
Okay. Talking about the neighborhood, what kind of neighborhood is this?
There's, generally probably about 20, 25 single family homes on First Terrace. Actually, I would say, probably just over a majority of them are rented out to students by various groups.
Okay. Will the expansion of the proposed use substantially change the character of the surrounding residential neighborhood?
No.
Is the expansion suitable in terms of effects on street traffic and safety with adequate sidewalks and vehicular access arrangements to protect the streets from undue congestion and hazard?
Yes.
There's not a lot of traffic on First Terrace, is there?
That's correct. There's minimal traffic.
Okay. And across the street from there is the stairs that go down to Lehigh University, or roughly somewhere in there.
That's correct. Yeah.
Will the expansion of the proposed use create any significant hazard to the public health and safety, such as a fire, toxic, or explosive hazards?
No.
Okay. And is the proposed use shall be suitable for the site, considering disturbance of steep slopes, mature woodland, wetlands, floodplains, springs, and other important natural features?
No, this is simply an addition of an additional level. There will be no ground will be disturbed.
Now, if the board were to find that the non-conforming use status has lapsed, what hardship would result from strict enforcement of the overlay?
Unique hardship exists due to location near Lehigh University and in an area suited for student housing. Relief won't harm neighborhood character.
Okay. How is this property uniquely suited for student housing compared to others nearby?
Like I mentioned, there's probably about 20 properties, and just over half of them are rented out to students. The street borders school property, and it has its own access to facilitate, getting to classes essentially. Given this information, it seems like the city overlooked including the street into the student housing overlay zone in the first place.
Okay. And would continuing student housing as a vested use change the character of the neighborhood?
No.
Okay. Is the request the minimum necessary to make reasonable use of this property?
Yes.
Okay. Have you acted in good faith to comply with all city requirements?
Yes.
And is your intention to continue using the property as a well-maintained licensed student housing facility?
Yes.
And do you believe approval of this request will benefit the neighborhood and ensure code compliance?
Yes, I do believe so.
Thank you. No further questions.
Thank you. I think I'll pass out my exhibit packets now. These have the raised stickers. Who wants them?
That's me. Thank you.
Okay.
Yeah, that was correct. Yeah, we just set for.
All right. Good evening, Mr. Glignani. My name is Matt Deschler. I'm an assistant solicitor with the City of Bethlehem. I just have a few questions for you, maybe more than a few, but I have some questions for you. In terms of Austin Saboni, what is Mr. Saboni's relationship to 436 First Terrace LLC?
He's a member and manager of Lehigh Properties GP LLC, the entity that solely owns 436 First Terrace LLC.
Understood. So both you and Mr. Saboni are members of Lehigh Properties.
That's correct.
And if you could look at the exhibit packet I gave your attorney, some of these may be duplicates, but we'll look at City Exhibit 1. I'll represent to you that this is a printout from NC Pub, the Northampton County Tax Assessment website. And just to confirm, if we look on the second page of that exhibit, it is the case that the property was conveyed from the estate of Mary Borso to 436 First Terrace LLC, August 30th, 2019, correct?
Correct.
And as I understand it, neither George nor Mary Borso were alive when you acquired the property, correct?
I believe so.
And the woman that you've identified as Kathleen, was that a daughter of George and Mary?
That's correct.
So it was Kathleen Borso, correct?
Yes.
And Ms. Borso was residing at the property in August of 2019 when you purchased it, correct?
Yes.
And I think you said she resided there until she passed away in 2024, correct?
That's correct.
And from the time that 436 First Terrace acquired the property until Ms. Borso passed away in 2024, was she the sole occupant of the property?
That's correct.
And you can put the exhibit to the side. So the next exhibit in the packet is a series of two images. the first image is on City Exhibit 2. Is that a front-facing view of the dwelling from First Terrace?
That's correct.
And the second page, is that a sort of aerial view of the property?
Yes.
And the property is identified with the red teardrop on it?
Yes.
And the property, it's located in the city's RT high-density residential zoning district, correct?
I believe so. I would have to refer to the
Can we
other.
just- Can we just
yeah.
agree to that?
I'll stipulate to that.
Yeah.
And Mr. Glignani, it is correct that the property is located outside of the city's student housing overlay district, correct?
Yes.
And the dwelling itself, it's described or it can be characterized as a single-family detached dwelling, correct?
Correct.
We can go past City Exhibit 4, or sorry, City Exhibit 3 for now. We don't need to address that. City Exhibit, some of these are out of order because I had to insert some after I labeled them, but the next exhibit in the packet is City Exhibit 20. This is a document that's titled Important. It says, attached, you will find a copy of Ordinance 4038, Article 1739, along with an amended copy of Article 1739 passed by City Council on May 21st, 2002. There's additional language in here relating to, and skip to the third paragraph, it is imperative that all property owners respond to the City Inspection Bureau, regardless if your rental units fall under the regulated rental ordinance or not. If you feel your property is not subject to this ordinance, please check no at the bottom of this form. State the reason for not having to comply and return it to our office. If no response is returned to this office, the city will consider your property subject to the regulated rental ordinance. Did I read that correctly?
Yes.
Now, did you or Mr. Saboni, in your capacity as members of the entity that owns 436 First Terrace LLC, receive this form?
Yes.
And the printed name and signature on the form appears to be that of Mr. Saboni, correct?
Correct.
And it's dated October 30th, 2019, correct?
Correct.
And is the no box checked?
No.
Right. So in other words, Mr. Saboni, and did he return this form to the city?
I believe he did.
So by not checking no, Mr. Saboni was conveying that he wanted the property designated as a regulated rental unit, correct?
Yes.
And as of 2019, I think your attorney went over this. The city did not yet have a definition or term or use for quote unquote student housing, correct?
Correct.
So that was City Exhibit 20. The next exhibit in the packet is City Exhibit 21. Now, I'll represent to you that this is a document the city had in its records relating to the 436 First Terrace property. And there's some information at the top. And this is essentially processed through the city's inspection process. But at some point, did you or Mr. Saboni, on behalf of the entity, apply for a sales inspection for the property?
I would have to get back to you on that.
Let me ask you this way. When you purchased the property or prior to purchasing the property, did you get a sales inspection?
We did.
Okay. Are you sure it wasn't? I'm not here to kind of bust you on that, but are you sure you didn't get a sales inspection after you purchased the property?
I would have to confirm with Austin.
Okay. Did you or Austin convey to the city that you wanted to lease the property to students?
It was always our intention. I'm not sure if there was a direct method of communication to the city.
Well, did you ever convey to anyone at the city that you wanted to lease the property to college students?
I think we've done so indirectly by applying for a regulated rental unit.
Did Mr. Saboni ever convey to the city that you wish to lease the property to college students?
I would need to confirm. I don't know.
If you look at this form, City Exhibit 21, there's an application date here, February 3rd, 2020. You see that?
Yes.
And this appears to be some kind of inspection form, don't you think?
Yes.
And were you applying to the city for an inspection of the property on or about February 3rd, 2020?
It appears so.
Do you see on the right-hand side of this form, it says requested by, and then it says Austin?
Yes.
Would that be Mr. Saboni?
Yes.
And that email address there, is that Mr. Saboni's email address, austin@lehighproperties.com?
That's correct.
And there's a phone number listed there. I won't read it out, but is that his phone number?
Yes, it is.
And there's the next line, it says remarks, 3 students, SFSDD. Do you see that?
Yep.
As of February 3rd, 2020, was it your intent to make the property available for 3 students?
Yes.
Even though this is a city form, the city would have no business putting 3 students on this form, correct? Unless it was told that by you or Mr. Saboni, right?
Correct.
And I guess as of that time, February 3rd, 2020, when you would be able to lease the property to students, was it your intent that that number be capped at 3?
I cannot speak to that.
All right, so that was City Exhibit 21.
If I can ask, the yellow highlights that are in there, is that anything?
I did not do that. That was just part of the record as it came to me.
Okay, it's fine.
And I'm
Just curious what it was.
I'm not really sure. Well, I think Mr. Simonson will testify to this. This is basically a field report that's done while the inspectors at the and
You'll get to it. I just
Okay,
didn't know
yeah.
what it was.
And Mr. Glignani, turning to next exhibit, City 4. And I'll represent to you, I know you've never seen this before. I think I will give it to your attorney, but this is a printout or a screenshot of some information that the city has in its housing records relating to the property. And there's an apply date, February 26, 2020. Do you see that on the left-hand side?
I do.
And it says a permit type, H sale of property. Do you see that?
I do.
And then for purpose special conditions on the right-hand side, it says sale will be RRU 5 students, March 12th, 2020, houses being renovated. Correct?
Correct.
That language I just read, would that have been language that, or a comment or a remark that you or Mr. Saboni provided to the city?
I suppose someone on our team did, but I do not know for a fact.
Well, similar to my question before, the city would have no business or reason to put this remark down there unless it was told to someone at the city by someone from the property owner, correct?
I suppose so.
Okay, so the next exhibit, City Exhibit 5. Now, this is an inspection report dated March 12th, 2020. Do you see that?
Yes.
And there was some language in that prior exhibit on City Exhibit 4 relating to a sale. Again, that was dated February 26, 2020. So now we're at Exhibit City 5, dated March 12th, 2020. Does this look like the sales inspection report?
It does.
And again, this was after you purchased the property, correct?
That's correct.
And we're not going to go through the whole report, but I think you testified even on direct examination. The property was inspected a few times, including, I guess, this time. On this inspection report, City Exhibit 5, there are a number of issues, defects noted, correct?
Yes.
So as of March 12th, 2020, the property was not, well, I guess Ms. Borso was still living there, correct?
Yes.
At that time, the city was not able to issue you a certificate of occupancy for the property, correct?
Yes.
City Exhibit 9, we will skip. City Exhibit 6, which is the next one. And okay, so this is a June 3rd, 2022 inspection report for regulated rentals 4436 First Terrace. You see that?
Yes.
And while the format looks a little different, I believe in the applicant's Exhibit 8, I guess that was
Yes.
intended to be the same exhibit.
It is the same exhibit,
Okay.
I believe.
And again, the inspection report that I have marked as City Exhibit 6, it noted a number of defects, issues, violations that would have to be corrected at the property, correct?
Correct.
And at that time, the city was not able to issue a certificate of occupancy for the property, correct?
Correct.
All right, City Exhibit 7, we can skip. City Exhibit 26, we can skip. City Exhibit 8, Mr. Glignani, this is a violation notice or an inspection report dated July 7th, 2023. Did you see that?
Yes.
And it looks like it was issued to, well, at least to Mr. Saboni's email address, right?
Correct.
And it references an inspection date of the property on July 5th, 2023, correct?
Yes.
And it says, you see where it says tenants 4?
Yes.
There weren't 4 tenants living there at the time, correct?
Correct.
And at that time, I guess there would have been 1 tenant, correct?
Yes.
And that would have been Ms. Borso.
That's correct.
If you look where it says violations noted, it says no access to home at time of inspection. Inspected must be done. That's what it says, correct?
Yes.
Is it true that did someone from the city come out on July 5th, 2023 and an attempt to inspect the property?
That appears to be so.
I think this may have been, you may have alluded to it before, but was getting access to the property an issue when Kathleen Borso was still living there?
That's correct.
And where it says, again, under violations noted, property cannot be rented until clear certificate of occupancy is issued. That's what it says, correct?
Correct.
And at that time, as of July 7th, 2023, the city was not able to issue a CO for the property, right?
Correct.
The next exhibit in my packet is City Exhibit 10. This is, or purports to be an application for, I believe, a regulated rental application for the property at 436 First Terrace. Is that correct?
Yes,
And it's dated, I believe, April 2nd, 2024, right?
correct.
And on the second page of the exhibit, it says at the top, important regulated rental units occupancy. There's a signature at the bottom. Is that, well, whose signature is that?
That's Allison Crescente. She works for the property management company.
What's the property management company?
It's LPM Group LLC. It was basically doing some services for Lehigh Properties GP LLC at that point in time.
Their name's listed as the property manager on the first page.
Okay. And Ms., how do you pronounce the name?
Crescente.
Ms. Crescente would have had the authority to execute this form for, I guess, both 436 First Terrace LLC and Lehigh Properties, correct?
That's correct.
All right. City Exhibit 22, we'll skip for now. City Exhibit 11, Mr. Glignani. So this is another inspection report dated June 19th, 2024. Did you see that?
Yes.
Did you receive this inspection report?
I personally cannot confirm, but it appears it was received by our company email.
And let me, when I refer to you there, I do mean kind of the company. So Lehigh Properties.
Yes, the company did.
Okay. All right. And the last inspection report that we looked at too, did the company receive that?
Yes.
And that would have been the one from, just so I'm clear, City Exhibit 8, the July 7th, 2023 report. The company received that one?
Yes.
All right, so back on City Exhibit 11, the June 19th, 2024 report, it references an inspection date of June 18th, 2024. Did a city inspector come out to the property on that date to inspect the property?
I do not know.
There's a reference to tenants 4. Do you see that?
Yep.
At that time, were there 4 tenants?
No.
And I'm not sure when Ms. Borso passed away. Had she passed away by this time?
I do not know.
But at most, there was 1 tenant residing at the property, correct?
Correct.
And fair to say that this inspection report lists a number of violations, correct?
Yes.
It appears that from the number of violations, there was some access granted or allowed for the city to get into the property and take a look at it, yes?
It appears so.
But if we look at the bottom of the page, the bullet point or dash, it does say property cannot be rented until clear certificate of occupancy is issued. No clear CO since 2007. That's what it says, correct?
Yes.
So at that time, as of June 19th, 2024, the city was unable to issue you a CO for the property, right?
Correct.
The next exhibit in the packet is City Exhibit 12. This is a violation letter dated July 30th, 2024, for 436 First Terrace. It's addressed to 436 First Terrace LLC. Did you, meaning the company, receive this notice?
Yes.
And it lists some, I think, perhaps these are the violations referenced in the magistrate dockets we saw earlier. But this letter references some violations of the regulated rental ordinance, that being Article 1739, correct?
Yes.
And the violation notice on this letter, that's City Exhibit 12, it says inspection performed on June 18th, 2024 has yet to be rechecked and abated, correct?
Yes.
And I guess the violation was that as a prerequisite to entering into a rental agreement or permitting the occupancy of any regulated rental unit, RRU, the owner of every such RRU shall be required to apply for and obtain an annual license for each RRU. That's what it says, correct?
Correct.
And I guess the inspections that were done noted violations that had never been corrected, yes?
Yes.
So the next exhibit, City Exhibit 13. This is another violation notice. It says final notice citation pending, dated August 7th, 2024, addressed to 436 First Terrace LLC, correct?
Yes.
And did the company, meaning the property owner, receive this?
Yes.
And the type of violation, that being Article 1739.04, it's the same violation that we saw in the earlier notice, yes?
Yes.
And the same, and the basis for the alleged violation is that the inspection performed on June 18th, 2024 has yet to be rechecked and abated, correct?
Correct.
Great. Next exhibit in the packet, City Exhibit 14. It's an inspection report dated August 8th, 2024, correct?
Correct.
And looks like there was inspection done on, well, it references an inspection date, June 18th, 2024, correct?
Correct.
It indicates that, and this is right above the violation noted line, first recheck, amended report, October 7th, 2024, no changes. That's what it says, correct?
Correct.
Okay, and there are a number of violations noted in this report.
Yes.
And on the second page of this report, first dash mark, again, it reads, property cannot be rented until clear certificate of occupancy is issued. No clear CO since 2007, correct?
Correct.
And again, as of October 8th, 2024, no CO could be issued for the property, right?
Right.
Next exhibit in the packet is an inspection report dated November 27th, 2024. Did the company receive this report?
Yes.
Okay. And again, the inspection date is listed as June 18th, 2024, referencing back to that date. And this is identified as the second recheck. Do you see that?
Yes.
And again, it lists a number of violations, correct?
Yes.
And again, on the second page of this report, the second dash mark, it reads, property cannot be rented until clear certificate of occupancy is issued. No clear CO since 2007, correct?
Yes.
And again, at this time, the city could not issue you a CO for the property, right?
Correct.
The next exhibit is City Exhibit 16. This is another regulated rental unit application, correct?
Yes.
And this was also submitted by the property owner, right?
Correct.
I know there's no date on this, but is this an application that was submitted by the property owner in 2025?
I do not know because this was submitted by the property management company.
Fair enough. We can skip Exhibit 23. The next city exhibit is City Exhibit 17. This is another inspection report, correct?
Yes.
And it's dated September 24th. There's a date of inspection, September 24th, 2025, correct?
Yes.
And the inspection type is regulated rental. That's what it says, correct?
Yes.
And did the company, the property owner, receive this inspection report?
Yes.
And it's indicated that the inspection result is fail, correct?
Correct.
And on the second page of this inspection report, it indicates that the question is asked, is the property clear of any additional violations? The answer is no, correct?
Correct.
And then it reads, property not occupied, not habitable, correct?
Correct.
And as of September 24th, 2025, was anyone residing in the property?
No.
The remaining exhibits, well, City 18 and City 19, I'm not going to go over with this witness. Just one thing here. Mr. Glignani, I have some additional exhibits I'd like to pass out.
Thank you.
This is for you, Steve. All right, Mr. Glagnotti, the first exhibit, City Exhibit 24, this is a subpoena that was issued by the Zoning Hearing Board, directed to Austin Saboni on behalf of 436 First Terrace LLC, requesting any and all leases in effect for the property located at 436 First Terrace, Bethlehem, PA, 18015, from January 1st, 2019 to the present. That's what it says, correct?
Correct.
And the company, the property owner received this subpoena, yes?
Yes.
And I know that City Exhibit 25 is the lease that you already presented as, just so I'm clear here.
Applicants 2.
Okay, applicants 2. But your attorney provided me this lease that I've marked as City Exhibit 25, correct?
Yes.
Now, since, and I know January 1st, 2019 is before you purchased the property, but since you purchased the property, your company, is this the only lease you've had for that property?
Correct.
I want to read something to you and ask some questions on that. So this is a definition I'll represent to you of the regulated rental unit from Article 1739, which is the ordinance governing regulated rental units. It's not a zoning ordinance, it's a separate ordinance. So this is what it says for the definition of regulated rental unit. A dwelling unit occupied by 3 or more, but not more than 5 unrelated persons under one rental agreement. Do you understand what that says?
Yes.
Using that definition, since you purchased the property in August of 2019, has the property ever been utilized as a regulated rental unit?
No.
I'll just read another definition. This is from the zoning ordinance, a definition of student home. Subject to the maximum occupancy limit set forth in Article 1727.02, a dwelling unit occupied by 3 or more students aged 18 years or older, but not more than 5, who are not related to each other, and each whom is enrolled at a college or university authorized to grant post-secondary degrees by the Pennsylvania Department of Education. A housing unit occupied by 1 or 2 college students shall be treated the same as any other housing unit of the same housing type and shall not be considered a student home. To qualify as a student home, the dwelling unit shall not be the residence of persons not enrolled at a college or university authorized to grant post-secondary degrees by the Pennsylvania Department of Education. The term shall not regulate housing for college students within the institutional zoning district. That's a mouthful, but you heard that definition?
Yes.
Okay. Since you purchased the property in August of 2019, has the property ever been utilized as a student home?
We have not been able to utilize it as a student home, even though it was our intention from the beginning for the circumstances that we went over previously.
And just so I'm clear, if you have your exhibit packet in front of you, okay, if you could just turn to Exhibit 11.
Okay.
Okay? Sorry.
11, you said?
Yep.
Out of order. 1 second. I got a bit out of order.
Yep, we have it.
Okay. So Exhibit 11 is a communication between, I guess, Mr. Saboni, but the property owner and a prospective student lessee, right?
Yes.
And the date of this communication is October 5th, 2021, correct?
Correct.
And Exhibit 12, applicant's Exhibit 12, another communication, correct, between the property owner and a student, right?
This was Exhibit 12.
Oops, wait, it's sorry, it's because I have a duplicate. Well, yeah, isn't Exhibit 12? also a communication between Mr. Saboni and a student?
Correct.
Okay. Right, and that's dated October 7th, 2021, correct?
Correct.
And just so I'm exhaustive on the dates, there are other dates here, October 6th, 2021, and October 1st, 2021, correct? If you go through the chain?
Correct.
Correct.
Okay. And Exhibit 13, again, this is another communication between Mr. Saboni and I guess a prospective student lessee, correct?
Yes.
And the date of this email communication is September 29th, 2021, correct?
Correct.
And I guess the second page of that exhibit, so applicants 13, there are other emails, or there's at least one other email. It's also dated October 5th, 2021. Do you see that?
Correct.
And continuing back through the chain, there's an email September 21st, 2021.
Yes.
And Exhibit 14, applicants 14, another email between Mr. Saboni and a prospective student lessee, correct?
Yes.
And this email is dated June 24th, 2021, correct?
Correct.
And on the third page of, no, sorry, the second page of that exhibit, looks like there was another email sent by the student to Mr. Saboni dated June 23rd, 2021, correct?
Correct.
And the emails that we've gone over here that are reflected in applicants exhibit 11 through 13, you have presented those as evidence of an intent to market the property as a student rental, correct?
Correct.
So, Mr. Glignani, when you purchased the property in August of 2019, you were able to lease it to at least one individual, right?
Well, I think we had to put a lease in place so that Kathleen could continue to lawfully live there.
You had a lease with Kathleen Borso, correct?
Correct.
You were able to lease it to this individual, right?
Yes.
And as of, let's say, March 2021, you were still able to lease the property to Ms. Borso, correct?
Yes.
And as we sit here today,
objection.
yes,
What date was that?
March 2021. It's the month that the Student Housing Overlay Amendment was passed or made effective.
Is there? No, I'll withdraw the objection.
In March of 2021, you were able to lease the property to Ms. Borso, correct?
Correct.
As we sit here today, no, sir, you can't talk to.
Apologies.
It's fine. As we sit here today, it would be possible, if you get everything fixed up, to lease the property to two college students, correct?
Yes.
You could lease it to one college student, correct?
I don't believe it would be economical for one student to occupy a property of this size.
I totally understand. I guess just as a matter of possibility, forget the economics, it would be possible to lease the property. If you get it all fixed up, get a clear CO, you could lease it to one college student, correct?
Theoretically, yes.
And you could lease the property, if you get it all fixed up, get a clear CO, you could lease that property to a mom and dad and a couple kids, correct?
Yes.
You had testified before that you had relied on, I think what you were saying were representations made by the city about the use of the property or the designation of the property. What reliance are you talking about? I don't want to put words in your mouth, but you were testifying that I think you relied on representations of the city that it was either a student home or an RRU, and I'm just wondering what was the nature of the reliance?
Could you please clarify the question?
Well, I guess I'll ask it this way. Did you in any way, do you believe that the city conveyed to you that the property was a regulated rental unit?
Yes.
Now, do you believe that the city conveyed to you that the property was a student home?
Mm, but there's no formal designation, no, that the city would be able to convey to us to confirm that.
Okay, so maybe I'll ask that question then. Did the city ever convey to you that this property was a student home?
I do not know.
Well, you know from what you know. I guess I'm asking you directly. Did the city convey to you personally, Dimitro Glignani, that the property was a student home at any point?
No.
Did this, and you believe the city did convey to you that the property was a regulated rental unit?
Yes.
All right. Did you rely on that representation that you say was made by the city that the property was a regulated rental unit?
Yes.
How did you rely on that representation?
Well, I mean, we had to pay fees associated with the rental, a regulated rental unit designation.
Is there anything else that reflects how you relied on that designation by the city?
I don't know the answer to that, honestly.
But what you're telling me, I mean, you have full knowledge and understanding of the operations of 436 First Terrace LLC,
Yes.
correct? And you have full knowledge of the operations of Lehigh Properties, correct?
Yes.
So just, I want to understand what you're telling me. The nature of your reliance, the company's reliance on the city's representations that the property was an RRU was that you paid the RRU inspection fees, correct?
Correct.
Is there anything else, any other way that you relied on the city's representation?
I can't think of other way.
And just going back, sorry. Okay, going back to City Exhibit 20. This is the RRU designation form. You have that?
Yes.
So this was dated by Mr. Saboni, October 30th, 2019, correct?
Correct.
And this would have been just 2 months after you acquired the property, correct?
Correct.
And at this time, had the city told you, as of October 30th, 2019, that the property was a regulated rental unit?
Yes.
How had the city told you that?
By issuing this notice.
Do you believe that this notice says that your property is a regulated rental unit or was a regulated rental unit?
No, we had to make an election.
Correct. You had to make an election by not checking the no box that the property was a regulated rental unit, correct?
Yes.
So you conveyed to the city that the property at 436 First Terrace, as of October 30th, 2019, was a regulated rental unit, correct?
Correct.
No further questions.
Any questions from the board? I'll kick it off.
Yeah.
The you had stated that when Attorney Deschler was asking you about what you could do with the house, and he asked you about 2 students and then 1 student. When you responded to the 1 student, you said that was not financially feasible, but you did not say that for 2 students. Would 2 students work financially?
I think just given, the mortgage associated and the overall operating expense of operating that property, it would still be the rental rate required of 2 students would be too high for them to sustain it and for us to be able to carry the operating costs.
I guess, do you know how many people have to be in there to make it work?
I would have to get back to you just because it's a precise calculation. I don't want to speak out of line.
At this time, have you been able to fix everything? Have you gotten a CO yet?
No, not yet. We just started the demolition work.
In accordance to the renovation and addition, or just
clearing out everything. The prior owner was a hoarder, so we had to first clean up the property.
So I have a question of timing. How could you be talking to students about a house that has no CO and so long ago? You have someone in the house, and then you're talking that you're going to get the inspections done, everything covered in that time.
So a lot of times leasing would be done for the next academic year. We would have planned accordingly and would go through the entire process to ensure the property would be compliant by the time they would need to take residence.
Okay. So going back to 2019, I mean.
Right.
Yeah.
We would be leasing probably for 2020 academic year.
Right. And the house wasn't available till
Correct.
2024.
I'm a little bit confused on that. Different timeline issue. So the resident Kathleen, you said she moved out or passed away and then therefore moved out in 2024.
That's correct.
But you were kind of advertising it as an open, available student housing all the way from 2020 or 2021. Whenever that first email, like we have 3 sets of emails, looks like 21, 22, 23, that has this property listed while she was still a resident, right?
Just to clarify, Exhibit 15 is from 2020.
Okay. So yeah. But still, like the point still stands, right? That you're saying you were actively including this property in an email to prospective Lehigh students while you still had your resident living there.
Correct. And I think, had there been someone who was interested in the property, we would make an alternative living arrangement because it is pretty common to have several properties vacant. And if someone was interested in that specific home, we could have moved her to another property.
So that's
Define her.
Kathleen, sorry.
okay. So no one really, basically saying that no students had actually applied to live at this property from the point of when you purchased it until she passed away.
They expressed interest, but it has not gone beyond that.
And did you explore other avenues of renting it or, outside of student housing? Like, did you explore avenues of renting it to just a single family or anything like that? Or you just said, until we find students to live here, she's able to live here rent free?
Correct. Because we would not be in a position to market it to anyone else given its condition.
And I don't want to get into an ideological battle here, but you guys buy properties to make money. So why was there an arrangement for this specific woman to live here? I mean, good for you. It sounds great, right? But we see a lot of these cases and not many people are as gracious and willing to be like, yeah, you can live here until we find someone else, right? Like, was there a specific reason why you purchased this property and then you let this woman live here for 5 years without paying rent? It just seems like an awkward arrangement. Like, did she work for you? Was there another arrangement at all? Or you just purchased it and you felt bad for her, so she was able to live there until 24?
No, we just felt bad for her given her situation.
And what exactly is her situation?
She was diagnosed with cancer and she had an issue with her heart.
So in this time frame that you were talking to students, that this timeline is what I'm going back to and what Lucas was trying to establish. The student overlay ordinance came into effect, so you knew this was coming, and you never had any other thought of what you could do with this house after it was vacant.
We just weren't willing to, like I said, take any legal action against her. And we were also just, busy with other projects and so many other homes where we prioritized making sure all of the other properties were occupied and leased for the following academic year.
Am I allowed to address this, which was included, not by either of them, but this? So we have a letter written.
I'm going to object to this, just so you know.
Okay, because we have a letter written here, and I don't know how this
can't
legal
cross-examine a
process
letter.
works. By John
Which
Mervyn.
Which letter is it?
It's by John Mervyn. It's dated. I don't know if it's dated.
January.
I'm going through the process. So let's, but I'm going to ask if this is something that I should consider.
Yeah, so the board, the city, as a courtesy,
Mhm.
when residents mail in correspondence relative to the zoning hearing, include it within the information given to the board. The applicant has the opportunity to object to that because there's this concept called hearsay. As Attorney Ricciuti said, you cannot cross-examine a letter. If someone wanted to testify, they should be here in order to stand by what they're saying and to subject themselves to that. The board does have some discretion relative to that, but I would say that this is textbook hearsay to the extent that Attorney Ricciuti is making that objection.
Okay.
Also, the board has had this, similar objections before. Someone in the back has their hand up. Who are you? Walk up to the microphone, please.
Hi, I'm Seth Moglen. I live at 726 Hillside Avenue, a few blocks away from here. John Mervyn has lived in the house next door all his life. John was unable to be here because he's physically disabled. He has been trying for months to find a way to testify before this body, given his disability and given the absolute severity of the parking crisis on First Terrace. He did everything in his power to find a way to communicate with this committee. He asked if he could testify by Zoom, if he could testify by phone. He is disabled. He has a deep investment in this as a neighbor, and it's the cousin of Kathleen Borso. And what we I, as a neighbor and friend, did everything in my power to find out how John's testimony could reach this committee. And we were told by the city that what he could do was to submit a letter, which he has done in good faith. And I understand that there are evidentiary issues. I'm aware of that. I just want to note that there is a grave injustice taking place if somebody with that direct a material interest in this issue has no means to testify before this body.
So Zoom was not made available.
Based on past experience, the technology was unreliable.
Yeah. And also, I mean, under Pennsylvania law, there's no entitlement to participate in the hearing by electronic means.
We attempted to do it in the past hearing.
And I hear the sympathetic argument that is being made, and it's being made compellingly, we understand, but the board has the rules of evidence. The rules of evidence, I can go through them, but there's exceptions to hearsay. Unfortunately, one of those exceptions is not the individual is disabled and cannot come. So although, and I mean, the board can feel, and I hear the sentiment being argued relative to, we sometimes get these letters and no one objects to them. But I mean, there's other means through which that individual could retain an attorney. They could have done, and I know there's a hardship and a cost that comes with that. But I mean, there are ways that can legally be done. So I mean, it's not for me to rule in the evidentiary objection. It's for me to articulate the law to the board. I would say that there's no exception to the hearsay rule, that the very compelling factual case that you made relative to it. I'm just telling you, and the either attorney in the room can speak to it, there's not an exception for a disabled individual, unfortunately.
Can I ask another follow-up then? So, I mean, it seems I'm fine with that, right? I think that makes sense. We're also talking about a woman who has passed away, and we're talking about her medical condition. And I have no evidence other than what he's saying that she had cancer, and whether or not this letter needs to be considered.
You can weigh his credibility.
Yeah, like this is, you know what I mean? This
testify-
tells me directly opposite of what you're saying. I will say that. And I'm fine with discrediting that,
And
but
that's kind of the issue. I
it
mean,
seems like hearsay on that side
you
too.
can cross-examine him all you want.
Okay.
You can weigh his credibility. You can't
Mhm.
weigh his credibility relative to evidence that is not in record.
Okay.
But you can weigh his credibility. You can cross-examine him. But I mean, it's kind of the issue. I mean, we almost have to take, and sir, I want to say you're doing a good job of articulating for your neighbor, but I mean, you don't know if the person with the letter is disabled.
Sure. Yeah.
You
Okay.
know, I mean, it's why the hearsay rules are in place.
Okay.
It's ultimately the board's discretion relative to it. I can articulate relative to the law. I'll also tell you that there's, in the municipality's planning code, it says the evidentiary rules apply, but that the board has broad discretion relating to them. But I mean, it would be my recommendation to the board to sustain the objection, and to the extent that there's if someone else wants to speak relative to concerns, that they'll have that opportunity. Attorney Raschuti will have the opportunity to cross-examine or object relative to that. So
Okay.
that would be my recommendation to the board, hearing what may be the unfortunate circumstances, would be my recommendation to sustain the objection to hearsay.
Do we do that now, or do
Yeah.
we have to meet
Yeah.
about that?
We'll sustain.
Okay.
So can I
So
continue with a follow-up
We're-
question?
We're not in public comment right now. All we're doing, we're going to come to public comment. We allowed that because, and sorry, we understand you were trying to advocate on behalf of the neighbor on this issue. We appreciate that. We will have public comment. We'll get to that. So right now, where we stand is we're within the board's questions of this witness.
So then I just want to follow up then. So Kathleen, who was living at the property, she did no work for you guys whatsoever in any sort of capacity to continue to live in that house.
Not that I'm aware of.
She did no cleaning of your other properties. She did nothing like that.
Not that I'm aware of.
And then she lived in that property up until she died in 2024.
Correct.
Okay. And then the property's been vacant since that, right? So 2024 she's died.
Yes.
And then that's kind of where the conditions of some of these like newer, not the past inspections, but like how is the condition of the property today? You haven't fixed what's been inspected, right?
Correct.
So someone can't just move in
Not at the moment.
Okay. And is in your mind, are you able to, without doing a full rebuild of kind of what you're proposing, could you just do what the inspection is asking for and turn it into a single family home?
I believe we would have to do further renovations to the property to make it habitable again.
Just to make it okay. All right. All right. I think I'm
Any other questions? All right. Just to make sure, is everyone sworn in?
Well,
Can I do a redirect before?
yeah, I was gonna say,
Yeah.
a couple more. Go ahead.
Thank you. All right. With regards to Miss Borzo and the lease, it was the intention that she was going to vacate the property. Is that correct?
Yes,
And the lease is dated till February 28th, 2020. Is that correct?
correct.
And she overstayed that lease?
Yes,
And the reason she overstayed that lease was because she got sick?
yes,
Okay. And you did not file a legal action against her at that time?
correct. We did not file any legal action.
Okay. Did she ever move out of the house, remove her things from the house?
No,
Are her things were still in the house as of this summer? This
I
past summer?
I believe so.
And you have removed those items now?
Yes,
Okay. And just to clarify for the record, you purchased the house and she signed the deed as the administrator or executor of the estate of her mother. Is that correct?
yes,
Okay. So she was residing in the house when you purchased it.
yes,
And she did no work for you or your companies?
not that I'm aware of.
Okay. With regards to whether or not you could lease out this property to students, did you believe prior to, let's just say, October 14th, 2025, that you could release this property to 3 to 5 students?
Yes,
And it was only on October 14th, 2025, when the zoning officer sent his determination that you learned you may not be able to do that.
yes,
Okay. And you believed that by registering the property as a regulated rental, you had the right to lease this property as a student rental as long as you kept paying that fee annually, correct?
correct.
And you did pay that fee annually.
Yes,
Okay. And you believe that you had a lawful use as a student housing rental backdated to 2020. Is that correct?
correct.
So whether or not this was a student home was irrelevant because that did not come into the definition. There was no definition for student home until 2021. Is that correct?
Correct.
Okay. So no one from the city in 2020 or 2019 told you it was a student home,
Correct.
but it was registered as a regulated rental unit.
Yes,
And did the city refer to it in correspondence to you as a regulated rental unit?
yes,
Do you currently have permits pending for work on this property?
yes,
Have those permits been released by the city?
no,
Is the zoning appeal one of the reasons that those permits have not been released?
correct.
Okay. I think you stated before, generally you rent a property over a year before it is occupied by the student, correct?
That's correct.
That's your business practice.
Yes,
So right now, you're already rented your properties for the school year that would start in August of 2026, correct?
correct.
And those properties were rented sometime in 2025.
Correct.
Okay. So when you're looking at tenants from 2020 and 2021, you're looking for August of 2021 and potentially August of 2022, correct?
Correct.
Okay. I don't have any further questions.
Recross.
Mr. Glignani, you just testified on redirect that the property was registered as a regulated rental unit. What's your basis for that statement?
We paid the fee associated with that.
And that's what you mean by it was registered.
Well, we received correspondence from the city where we were expected to make an election and make appropriate payment.
Right, and you made that election on the document that we've identified as City Exhibit 20, dated October 30th, 2019, correct?
Yes,
And the fees you were paying were fees to get the property inspected as a regulated rental unit, correct?
yes,
You wanted the property to be inspected, right?
yes,
You paid the city to do the inspections, right?
yes.
The city came out and did the inspections, right?
Well, to some extent, I think they were denied entry on a couple of occasions, but then as it turned out, I think there was partial entry at some point.
Right, the city either came out and did the inspections or tried to do the inspections,
Right.
correct? Okay. So when I get back to this issue of it being registered by the city, why do you think the city registered this? Why do you believe the city registered the property as a regulated rental? Just because you paid the fees?
I do not know what the legal definition is of being registered as an RRU, but we made all the efforts to get it registered.
Right, but you wanted the city to inspect the property, right?
Yeah,
And it either did or it tried to, correct?
correct,
And it produced for you an inspection report, correct?
correct.
And since Kathleen Borso died in 2024, the property has been vacant, correct?
Correct.
That's all I have.
So we're going to allow the public to ask questions.
I have another witness, just
Yeah, that's what I was about to say. So what I want to do before the board's benefit and the public's benefit is I want to lay the map on what's going to happen from here. What other witnesses are going to testify? So Attorney Raschuti, who else will you be
I have
calling
Gary later just to talk regarding the special exception.
for the expansion of the non-conforming use? You have, that's the architect.
Yes.
So there'll be an architect that'll be testifying about the work that's being proposed and the special exception. Are there any other witnesses other than that?
No.
Matt, any witnesses on your end? Or Attorney Deshler, I'm sorry.
It's fine.
I called him Attorney Raschuti. I gotta be.
I have Mr. Simonson, the city's code official, to testify regarding Mr. Taylor. I can call him as well. I don't know if Mike wants to call Mr. Taylor, because of the issue with the interpretation, but I don't know how you want to address it. It's up to you if you want to call him on your side or not.
I could call him. It's not I think the issue, he read the interpretation. I could examine him on that, but I'd be calling him as of cross.
Okay. I mean, I
So
will
if you're going to call him on your side, I will just cross-examine him to save the board
fair enough.
some additional questions from me.
So what
then I have two.
Well, I'm sorry.
Then I have two witnesses.
Okay, so for the public's benefit, we're going to have some more witnesses. One witness is going to be the architect.
Yes.
Then there'll be the code official, the zoning officer, and then the public will have their chance to make statements. So where it stands now is that the public has the opportunity to make standing unless there's objection has opportunity for cross-examination, unless there's any objections as a standing. So is there any members of the public that have questions? This is not statements. I promise everyone you'll have opportunities to make statements, but if any direct questions, please come up. When you come to the mic, please state your name, spell your name for the stenographer, and please provide your address.
Just double check everyone's sworn in.
Yes. My name is Dan Osborne with Amicus Properties. Dan Osborne, DANOSBORN.
And you were with whom?
Amicus Properties,
And spell that, please.
AMICUS.
Thank you, sir.
Yep.
And address.
506 Thomas Street is our office address.
Good, sir.
Okay. My questions are
What's his position with the company?
operations manager.
All right.
Is that all? Okay. My question is, with the understanding of the non-conforming student housing area, if this is accepted, as any other house that's been affected by this accepted? Because that sets a precedent that it would be so.
So let me be clear. I'm sorry. Something, and thank you, by the way. I did not make this clear.
Nope.
Questions for this witness?
Nope, just my questions for.
No,
the
if you want to make a
board,
statement,
panel.
the board will not answer questions later. I can answer questions relative to those things. But the board's here to kind of act like a judge.
Okay.
But I mean, if you have questions of this, I'm sorry, I wasn't clear on that.
Is there a
Questions?
time frame during this that we would be able to ask these questions?
No, the board will not answer questions and I will not answer questions. The zoning officer during his cross-examination may answer questions depending on what they are.
Okay.
But I mean, it's, this right now, it's a trial.
Okay.
That witness just testified. That witness is being cross-examined. These folks are the judge.
Okay, and when would that time be for us to
Make statements.
submit a statement or question
After
regarding
after
this?
these two close, after
Okay.
the city and after the applicant closes their record, the city will put on their case. After that, there may be redirect like there were things you saw happening.
Mhm.
After that, you'll have your opportunity.
Okay, thank you, sir.
Good question. I appreciate the clarification. Go ahead, sir.
Just a couple quick questions for you. Am I right? Your name is.
Sir, I'm sorry, name and.
Oh, I'm sorry. I did that earlier, but I'll do it again. First name is Seth, Seth. Last name is Moglen, Moglen. I live at 726 Hillside Avenue, which is a few blocks from the
Yeah.
property.
Unless the stenographer disagrees from now on, you don't have to spell to provide the address. Just state your name, please.
Seth
I
Moglen.
mean, going forward, you're good.
I'm good.
If you come
Okay.
back up later, you're
Good.
good.
Very confusing. I'm sorry. Your name was Mr. Glignani?
Yes.
Yeah. I just wanted to ask a question about two things you said. One thing you said is that there's minimal traffic on that road. And keep in mind before you answer that I live here. You said there's minimal traffic on this road. Am I correct that there are hundreds of cars a day driving on this road, which is an entrance to Lehigh University?
It's a very specific question. I do not know the answer. I don't spend as much time in the area as you do.
Right. Can you explain what you meant by minimal? You testified there's minimal traffic on this road. This is relevant to the question of whether the expansion would have effects. You testified that it was minimal. Can you explain what to the board what you mean by minimal?
I mean, this isn't the main road.
Oh.
This isn't the main road going through campus. It's an adjacent road. I mean, as you can see, most of the major Lehigh University buildings are, a little further away. To my knowledge, it's the traffic on this street is mostly tenants and residents that reside at these properties. But as I mentioned, I do not spend nearly as much time in the areas you do.
The second question is about your testimony that, and this is also in the application, that this property is uniquely suited to serve as a student rental. Can you explain if the property requires dramatic expansion, doubling in size, in order for you to rent as a student rental? Can you
object to that?
Uh,
It's not doubling in size. So you're putting facts that aren't in evidence. So.
how would you, what description would you say? Adding additional bedrooms to the property
So-
would be necessary. My question,
Just to be fair, just back up and just rephrase the question without that characterization.
right. So my question is, when you say it's uniquely suited to serve as a student rental, but it requires a significant expansion for it to serve as a student rental, can you explain what you meant by it's uniquely suited?
Can we just clarify? We're not saying that it needs an expansion to serve as a student housing rental. We're asking for an expansion to go from what it is now to increase the non-conformity by up to 50%.
So to your point, this is an important thing for the board, I think, as well.
Yes.
The board could grant, and I'm not saying the board will do anything, but if the board granted either the appeal or the use variance, it could deny the special exception for the expansion. And your position is that it could still be used for, you're not requiring any variance relative to the expansion. Those two they're independent forms of relief. Is that right?
Correct. The expansion does not require any variances. It requires a special exception, which was what our original relief request was until the zoning officer changed his opinion. Therefore, then we were back here. We amended our application to ask for an appeal of his interpretation or a variance based off of that.
No, I mean, keep asking
Clarify.
questions you have, and I just wanted to make that clarification. I wanted to understand that too, so I appreciate the question on it.
Yeah.
Do you have any other questions?
The only follow-up question is, you testified that it wasn't viable to rent it to two students, but that it's uniquely suited to student rental as it stands. I'm just asking if you can clarify how those different statements can both be true.
Well, I think my statement that it's uniquely suited for student housing was guided by the location of the property and just, I guess, the proximity to campus facilities.
I understand. Thank you.
Can I ask a question?
You can always ask questions.
All right. If this wasn't student housing, do you need any?
No. You're gonna
Nothing
ask me,
to,
do I need a variance?
yeah, or a special exception to expand the house?
No, we don't. And Mr. Taylor can confirm, I did ask for that permit to be released for for them to build this. It's being held by the city until this hearing is resolved. Because if I don't know, I mean, they wanted to get the work started because it's all kind of combined. They said they're not going to release it because the issue of student housing was still whether it could be used as a student house going forward or not. It was unresolved. But it does not, and Mr. Taylor confirmed, it does not need any dimensional variances or other relief. Is that correct, Mr.
To
Taylor?
be a single-family dwelling.
It would
now.
be a single-family dwelling, yes.
So just so your expansion, like we need to think of this as two separate, like your expansion can happen if the first part gets
Yeah,
denied.
the only reason we're here from the expansion part is because under the zoning code, the use is now, let me just clarify how I say this. If the use of a student housing is determined by you, it's a non-conforming use now because of the change in zoning in 2021. Yes, sure. Can you confer that? Okay.
And I do as well.
And under the zoning code, a non-conforming use can be expanded by up to 50% of its current floor area. So when Mr. Later testifies, he'll testify as to what the current floor area is and what the proposed expansion is.
Yeah, the expansion of itself isn't requiring the relief. It's the use of the expansion.
Yeah, it's not a variance relief. It's a special exception to say that we're expanding this non-conforming use and you can have to approve it as a special exception. So it's a permitted expansion subject to a special exception.
If it's a non-conforming use.
If it's a non-conforming.
Yeah, that's the gatekeeping
If you determine
question.
it's not a use, we don't have to come back here to get the permit released. It's just get released at that point.
I mean, I guess, and this, I'm sorry if this is out of line. Does it make sense for us to meet and determine the first part of this before we go through to save everybody some time? But I don't, like I said, if I'm out of line, I apologize, but
Attorney
I don't
Deschler and
know
I
if
will
that is
probably
a.
ask at the end. I think we would like to submit legal memoranda on the issue of the nonconformity vested rights.
Yeah, and again, I mean, I know some members of the board are, I don't know if you've been through that procedure before. When one's this complicated with this many exhibits and this many legal issues, sometimes what we do is rather than vote at the end of the hearing, we'll set a schedule where the transcript will be typed up.
Okay.
He'll submit a legal memorandum for you to read. That'll give all their arguments in a very concise and outlined fashion with all the supporting law. The city will give theirs. And tonight we'll schedule a date that will come back, and you have been here when we've done that, where you will then render relief based off of that.
Okay.
We'll get all the evidence in the night. I mean, bifurcating it.
Yeah, that was my worry is like, it seems like we're just like pivoting here to like, I have all of this in my mind, and then we're going to pivot to like what seems like a completely separate issue,
I
honestly.
hear no attorney Raschuti. I don't think the architect's going to be up very long.
10 minutes.
Yeah, it's better. It's Kennedy's better for
I
the
crossed
board.
out a few questions already, so
Yeah,
I
I
was
know.
trying to get him quick and out.
Yeah, it's not even the
know that.
time. It's just more of like we're in this moment of like thinking
No,
in this, and then
Yeah, but
just it like
And
then
I-
it just, you know what I mean?
I
more
understand. That's why
from-
I wanted to
yeah.
mention that Matt and I did talk, Attorney Deschel and I did talk earlier, I think today or yesterday, regarding we will ask for memoranda to be
Okay.
submitted just
My,
because
my recommendation to the board is get all the evidence in. I'm with
Okay,
you.
that, yeah, I'm happy to.
just because
yeah.
it is more of a complicated legal issue with that part of it.
Okay, yeah, happy to.
Vested rights. I believe that would require issuance of some permit that the city later.
I heard that as well. I mean, I didn't say that in the application. Are you asserting vested rights argument?
I think we did.
Oh, did you? I may have missed that. I saw vested non-conforming. I didn't. Yeah, I read that in there. I was curious about that. So you do intend to present so for the board's benefit, there's a different form of relief called a vested right, and I mean they can do that. But it sounds like you do intend to raise a vested right argument. Is that right?
Yeah, I believe the non-conforming use is still vested, is what I wrote in my thing. So I will argue vested rights there.
I look forward to seeing your memorandum.
Oh,
go
I
on it then.
look forward to
So-
writing it.
It would be nice to clarify, because I think the city has kind of a right to.
Oh, relative to
Right.
your cross-examination, yeah.
Mike, when you say a vested if it's a non-conforming use, it's a non-conforming use, but I think vested rights is a different doctrine.
There's a lawfully issued permit that you rely upon for a vested right.
I understand.
So, what I'm saying is, you're not making that argument, are you?
No, I'm not making that we had a permit that was, but I believe we have a vested non-conforming use based on the actions of the landowner prior to the change of use in 2021, or prior to the change of the
Let me tell you
statute.
something. I think we're arguing about this, and I mean, I haven't heard evidence of a permit. So if he's going to argue it,
Oh,
yeah.
Correct.
So
I think I understand what he's saying, because they are two different concepts.
I agree.
It sounds like it's just the non-conforming use issue.
He's arguing that the non-conforming itself became vested.
Correct.
Relative to the student housing, not that there was a lawfully issued permit.
Sure. I'm not arguing there was a lawfully issued permit.
We
All
have a 3-minute break.
I was going to ask the board. I think you all have been very patient. I mean, do we think that a 5-minute recess for everyone, and to the public's benefit, this is just stretch your legs and catch your breath. All right.
Do we have to do anything special?
So
No, we're just going off more. We're going off of the record. No recess.
Going off the record.
But there's
I guess I'm
another.
not needed.
I
for
was gonna
that.
say, I mean, I feel
You're
like,
so kind.
yeah, I just feel bad
I had
for
a
you
long day.
because it's just like
I
we
know.
can do it as a
If I had
3.
my way, I would have moved the other one ahead of this in order to get you out of here. But
But I guess
I could argue this.
We can do it as 3 and she can go.
argue this.
I agree with that.
Yeah, I just feel like
fully agree.
this is going to be another hour.
No, I fully agree that if we maintain a quorum, I see no point you have to be here.
Yeah.
I did the right thing all along.
You always do. We appreciate that about you.
Yeah, we do.
All right.
Well, then I'll take my leave.
All right.
Thank you, guys.
Yeah, sure.
Thanks for sitting here with us.
Yeah,
good.
thank
Just
you.
Sitting here, keeping my mouth,
You wanted to jump in. I know you did.
sitting here.
Trying to read
I'll
your
leave all
mind.
that there. I'll leave all that
I wish I
Okay,
thought of that
perfect.
an hour and a half ago, Dr. Van Wert.
right. I know, right? Why did you speak up sooner?
I'm sorry.
Yeah.
All right, board, I'll see you in a month.
All right.
All right. Yep.
Exciting. Next one might be exciting.
Yeah.
I mean, this one's exciting.
I didn't.
I think.
Hey, do you want to stay and listen to the?
Well, that's that. I think we should just try.
Are we gonna jump?
Hey, John, staying, listening to the end?
No, I've been graciously given leave since I'm really not fundamental in any way, shape, or form here.
That's not true. That's. She just wants to go back out in that cold.
Right? No way, Jose.
You walk here, Paige?
Huh?
Walk here?
No, I drove right here
Okay.
from the nursing home.
I know sometimes. Oh,
2 questions.
Yeah.
Ah, parked on the street though. Good evening.
Yeah, me
Yes.
too. Oh, sorry.
We've met before.
I didn't tell you. I did not.
No, she didn't. I mean, I guess you would, but it probably just. You know what I mean?
I said, or her designated representative.
Yeah. No. I mean, maybe something like that too, but I doubt it. Yeah, go to that cow. I was not.
Done with that.
All right. I took Newton bar. I am no longer angry. When I meet with my dietitian tomorrow morning, the answer is.
Satisfied.
Oh, I was.
Hey, nice to see you, Seth.
Thank you for serving on this. I know this is a difficult,
It is hard.
thankless process. It really is. So I'm always grateful. to
Thank
people who
you,
serve
thank
on
you.
this.
Now watch this. Page left. So I have dibs on her water.
There you go.
I genuinely know what the next step is in this process. I feel as if a member of our community has been disenfranchised, and I don't want to put pressure on anybody. But
Am I able to open with a question for
simply
you
don't
or for
believe
David Taylor? Like,
it's here.
I'm confused with certain things.
With
So
what?
I want to know the difference between a regulated housing unit and a student housing unit.
He's going to testify later. I would ask him that question.
Okay. So hold on.
Okay. That is, when he testifies, that's absolutely something you can ask him.
Okay, all right.
I don't really.
Let me say this. If not, when we eventually deliberate on this, I can certainly help you answer.
Okay, all right. Currently not set up for that kind of testimony. And it is the fact that oftentimes when you have. All right, but you have a procedure. You have in-person testimony. That is the case. I mean, we're not set up apparently for remote testimony.
I'm glad that you wanted
I don't really have anything else to add.
I was like,
In our
When I saw
defense,
that,
we
I
had no
was
idea the
like,
guy existed until I got the letter today. Yeah.
One day.
It was sitting here for me when I got here. So I never heard of the guy. No one asked me about remote testimony.
I mean,
hearing you're from a building,
Yeah.
from a builder, I love that.
it's cool to have
I
like
feel like I
unique
want to ask stupid questions.
Right.
Things that I
like,
should-
perspectives on the board. When I first served, I was lucky enough, like when I was an alternate, there was two lawyers. There was a chair. and
Never.
everything else, but
No one asked me about if he could
Thank you.
testify or not.
somebody
Yeah.
that-
Exactly.
Like I said,
in Bob Stoll's office was had a really good understanding of the permitting processes. And then there was
We
just
doing
one
okay?
guy that loved this community.
Oh, that's a nice family.
Doing-
Yeah.
okay?
But I learned so much.
Because,
That group of people
David, I know
have been
We're gonna restart.
Okay.
for years.
Everyone, just let everyone know, we excuse Dr. Van Wert since we have a quorum of the board, since this is gonna go longer. So Dr. Van, we excused her from the balance of the hearing since she was not participating. Do we have, Mike, do you have everyone?
Yes.
And so we have everyone here. Public looks like they're all here. All right, back on the
All right.
record.
Go back on the record.
All right. Mr. Later, you were sworn
Oh,
in.
let him get
They
the,
were on.
They're on. Yep. Mr. Later, you were sworn in, correct?
Yeah, that's correct.
All right. Could you just state your name and business address?
My name is Gary Later. My business address is 414 West Broad Street in Bethlehem.
And can you spell your last name for the,
LA as in Apple, D as in David, ER.
and you're a licensed and certified architect?
Yeah, that's correct. I'm a
And-
licensed architect.
And you've testified before zoning hearing boards before,
Correct.
including this one?
Correct.
Okay. And what are your licenses and certifications?
I'm licensed in the state of Pennsylvania to practice architecture and in the state of New Jersey to practice architecture.
Okay. And were you hired by 436 First Terrace LLC to design a second-story addition for in the attic space of the property at
Yes.
436 First Terrace?
That's correct.
Okay. And how long have you been working on this project?
I started working on it in March of 2023, and I see we had dated our permit drawings in January 24. So, that was about a 9-month span. And then in the summer of 2025, we were asked to look at parking issues and fixing a retaining wall.
Okay, so it's been a couple of years you've been working on this.
Yes.
And during that time, you've had discussions with the city of Bethlehem?
Yes, that's correct.
What officials in particular?
I spoke with Dave Taylor.
Okay.
Or email.
And during that time, were you ever told or aware the property could not be used for student housing?
No.
Okay. Can you describe the property at 436 First Terrace?
Sure. It's a 1.5 story single family residence. I call it a Cape Cod style.
And how many square feet are in the property?
About 940 square feet.
And that confirms with the tax records?
Yes, that's correct.
Okay. Looking at Exhibit 16, there in front of you here. Did you prepare this?
Yes, that's correct.
And is this the rendering of the proposed addition?
Yes.
Okay. And just kind of looking at it, can you just describe the proposed addition?
Sure. It's mainly to reconstruct or provide an entire new second floor over the existing first floor footprint.
Okay. And how many square feet of added space would be added with the addition?
Well, it's approximately 328 square feet. So in other words, if we take the, approximately the existing area that was there and add to it, that's, an additional 328 square feet.
Okay. And as you're aware, the applicant's asking for a special exception to expand a non-conforming use as a student housing if that is determined to be the existing use. And does section 1323 of the zoning code, 1323.04 of the zoning code permit an expansion of up to 50% of the non-conforming use measured by floor area of the existing use?
That's why I understand.
Okay. And does the addition create any additional needed variances?
None that I know of.
Okay. And the additional 328 square feet, that's about 34% of the floor area, is that correct?
Correct.
Okay. Has the owner made any other additions to the property since purchase?
No.
Okay. If the property is determined to have vested rights or vested, I don't want to say vested rights.
Just say non-conforming use.
Yes, yes. The property has non-conforming use as a student housing. Is the expansion of a non-conforming use permitted by the special exception?
Yes.
Okay. And is the expansion in conformance with all applicable requirements of the zoning ordinance?
Yes.
And one of the issues you mentioned, looking at Exhibit 17, there was some additional off-street parking that was needed, correct?
Correct.
And did you have this prepared, Exhibit 17?
Yes. Yes. We
And how many
prepared that.
spots does that add?
We added 3 off-street parking spaces.
And that met the needs of the additional parking that was required?
Yes.
Okay. And is the proposed use suitable for the site, giving considering this disturbance of any steep slopes or mature woodlands or anything in the area?
I believe so, and that's because there currently is a lot of student housing along that street and area.
And is any ground being moved with this expansion?
Not with the expansion,
Just the parking?
just with the parking.
Okay. I have no further questions.
Mr. Later, you testified that David Taylor never told you that the property couldn't be used for student housing. Is that correct?
Yeah, that's correct.
Did you ask him?
Well, I think when our communications began, it was expressly that, hey, we're planning for student housing, and I wanted to know more information about how to provide parking.
City's never approved this project as student housing, correct?
Once I completed my permit drawings, I was, I think it's entirely up to the owner for submitting for permit.
I understand that the owner and your drawings reference student housing, right?
That's correct.
But that's just your representation, correct?
I'm not sure what you're getting at.
Where is the imprimatur by the city that this is student housing?
Oh, okay. Well, I think usually my intention when preparing drawings is that the city understands what our intention is.
I understand. I mean, let's say that you submitted an application. Let's say you submitted drawings for a power plant at this property, right?
Right.
Probably that's not permitted in the park district, correct?
Probably not.
All right. But the city, in accepting that plan, would understand that the
Mhm.
intention was to build a power plant there, right?
Yep, should be.
It would be denied, but that would be the understanding.
Right,
correct?
right.
Right.
Okay.
So here, your understanding is you wanted to put student housing on the property, right?
Right,
And then when the city reviews the plans, they understand that you want to put student housing there, right?
right. Mhm.
The city's review of the plans is not an approval of the proposed project for student housing, correct?
Correct, but I think the expectation is they review it and then, would advise us or issue a permit, hopefully.
Well, we're sitting here tonight, and the city's position is this was never student housing. You understand that, correct?
Correct.
So effectively, the city's telling you this was never student housing, right? I'm telling you that. You understand that? My
Okay.
words, I'm saying this was never student housing. That is the position of the city, right?
Well, I'm sure I understand that's the position of the city. I'm just not really sure what that has to do with what the drawings we're submitting.
Well, my question stemmed from your testimony that Mr. Taylor never told you it couldn't be used for student housing. What
Okay.
I'm saying is in the fact that the city is conveying to you, to your client, that this property can't be used for student housing, and it never was student housing, right?
Well, okay, I understand it wasn't student housing before. I know from experience with at least half a dozen projects we've done on the street that, the goal is usually to do work on them to make them suitable for student housing.
Is it the applicant's position that by labeling these drawings student housing, that created any acquiescence or right from the city?
One of our arguments, I would say.
Okay, thank you.
And-
And Matt, please continue.
And
I don't think I have any further questions.
I have a brief redirect, but if the board has questions first, I will wait.
I would wait until they go through and then. Yeah.
I guess, wait, these were, where does it say? Oh, I see, student housing. So in submitting for permit, and maybe this is a question for Mr. Taylor, my assumption is that plans also go through a zoning review, which is why he puts the zoning information up here.
Well, I'll wait for Dave then, for that.
All right. Oh, I guess, is that you submit these drawings with that information because you know that zoning is part of the permit review?
We usually try to at least include some zoning data for the benefit of review by the city. And, you know, I think
Which kind of led you to your question about parking, to make sure that you were, my guess is within the zoning, meeting the zoning ordinance.
You know, I gotta be honest, when we first got involved with the project, it was really to try and do renovations and accommodate additional bedrooms. You know, the issues with the parking came about later on, and you know, in the course of things, I don't even really remember how it came up. I don't know if zoning had reached out to our client first.
That's okay. I guess I'm a little bit confused at have you received comments back or any kind of approval for your submission? Like there's no permit yet?
I have not, but that doesn't necessarily mean anything, because it's very typical. See, as the architect, I'm not submitting for permit. It's usually the contractor who submits for permit, and then if they get comments,
When were the drawings submitted?
When were the drawings
When?
submitted? I do not know. All I could tell you is we issued them on January. We issued this for permit on January 24th to the owner. So
Of what year?
I'm sorry, January 2024.
I'm sorry. I thought you meant January 24th. I'm sorry.
Yeah, I know.
So January 2024, you drafted these drawings and they presumably were submitted to the city from there.
That was my understanding. I don't know for sure.
And you put student housing on there
Yes.
based off of instruction or representation from your client.
Correct.
Okay. And I get your argument, Attorney Raschuti, relative to reliance from there. Sorry, I didn't mean to jump in.
No, it's fine.
Timeline.
And I guess, as far as you know, there's been no return or comment on your drawings.
As far as I know.
Has there been? I'm sorry. You
No,
can go.
no, I just had a quick question about the parking. I just wonder where the access to the parking, how the access is going from to the parking, and can we go over that a little bit?
Did they not receive copies of this?
Yeah,
I don't know if we have.
it's exhibit 17.
And I think that was submitted independent of this.
Oh,
draw.
so it's in our other
got
packet?
it.
It was, yeah.
It's a single thing.
Okay.
Sure. No, they have it.
Okay.
It's a different plan set.
Yeah, it's not on the same plan set. No, it was after.
Right, so it was submitted in 2025.
Can you show him? Yeah, you have exhibit 17. Can you show
Yeah,
him
it's
that?
right here.
So can you on that
explain
drawing,
that?
can you show the
Oh,
board where the parking is accessed from?
Yeah.
Oh, okay. All right. Well, it's accessed from First Terrace. you
Okay,
know,
from First Terrace.
It's kind of similar to the driveway next door.
All good.
But is you're not asking for any parking relief with,
No,
There's no parking relief needed. And I can ask Dave Taylor questions about this, is how it came about.
Fair enough.
I just wanted to see where it was in relation. Thank you.
So there's I mean, I know we don't go off of precedence here, but there's I'm assuming you've done drawings for a lot of student housing
for this client.
for this client, but this isn't the first time you've been brought in for student housing, right? You've done how many drawings for student housing?
Yeah, at least one project to my memory within the past year or two.
Okay. So not extensive then, though. Like this isn't something you're doing drawings for student housing all the time. I guess what I'm getting at is that, like, how often would it get to the point that you're submitting drawings that say student housing on it, and then suddenly that's what's being flagged as like, wait a second, this isn't student housing. Like, I don't know how we got to the point of doing drawings for student housing without anybody in the past from the city basically flagging that you can't do this with, you can't build student housing here.
Well, if it's student housing, I always put it in big letters at the top of our drawing, and I always include a little description that this is what we're trying to do.
Have you had an instance in the past where you've done that and then that has led to it being flagged as saying this is not approved for student housing?
No, have not.
Okay. I don't think I have any other questions.
I'm good. I'm good.
I do have a question. Mr. Lader, the proposed improvements or expansion of this single-family detached dwelling, that would not constitute what we call land development, correct?
Correct.
So really, the relief you need here is zoning relief and a building permit, correct?
Correct.
Now, for a building permit, the code official doesn't really care whether there's students in there or related families, correct? You just get a building permit.
That's.
I think
I'm going to
the,
object to the question. I don't know if draws speculation. I don't know if
I'm getting
he's not
at
a building.
what approvals they actually need. I mean, for the building permit, it doesn't really matter if there's students in there or if there's a mom and dad or two kids, right? To do just to get the building permit for the expansion.
I'm going to object because it does.
Wait, what's the objection?
Well, he's I'm objecting to the form of the question, I guess, in the sense that, well, let's just say, I believe he's putting facts that are not in evidence in his question because.
Can we ask Dave that question later?
Fair enough.
Okay.
Because a building permit, and just kind of just explain.
I get that it comes after the zoning permit, but the building permit, it comes after the zoning permit, and it's related to the
But they-
structural issues.
I
They
don't know
won't
if he-
issue a building permit on this unless we have special exception relief for the student housing.
I agree, but.
I'm actually going to sustain the objection as a legal conclusion. Is
Okay.
actually what I think it is.
All right.
Okay, so, but just, Mr. Lader, you do need zoning relief, correct?
yeah, I think so.
That's why you're here, right?
Right.
You're here, and you believe that you're entitled to a special exception, correct?
That's correct.
To expand the non-conforming use, correct?
Right.
And one of the elements to get a special exception to expand the non-conforming use is that there be a non-conforming use present on the property, correct?
Correct.
And the city is here opposed to that position, right?
Oh, it looks that way.
I hope so. Or I'm fooling people. All right, thank you very much. That's all the questions I have.
So, Return Shitty, can we do the public then redirect?
Yeah.
All right. Questions from the public? Again, questions of,
Yeah. Seth Moglen. Mr. Lader, question about the parking. I want to ask a little further about that. You said that you were originally hired to do the architectural work, the expansion. Parking came in later.
Correct.
And in response to questions, you said, well, yeah, the parking would just kind of be like the driveway next door. And well, other student rentals have parking. Am I right that so I want to hear more about what you're proposing for the parking. Am I right? You're basically proposing putting parking spaces where that retaining wall is,
What
more or
we would-
less?
What we would end up doing is cutting down part of that retaining wall so that, we could accommodate a standard size parking space.
Right. So there will be earth moving involved in that to
Yes.
make that happen. The picture you showed us of the driveway next door is the neighbor who attempted to do this at his own house and was told by the city, you cannot do that because of steep slope and drainage issues if you actually try to put a parking space, if you try to put parking spaces in front. In fact, something similar has been done by the same property company at the other end of First Terrace, which I'm pretty sure is illegal. That's speculation. The question I'm asking you is, did you actually talk to the city about the drainage steep slope issues that would be entailed by putting 3 parking spaces in front of that house?
Right now, we're at just a schematic design level, but we had conversations with zoning about it.
if I can ask a question based on that, will there be a land development plan?
Yeah, I mean, look, I was looking at more like a civil engineering design. But,
No, I'm trying to get the same way. I'm trying to get an answer relative to that is often there's several steps in this process where there's zoning and then there's a land development. Attorney Rashidi, do you know, will there be a land development plan?
If yes, there
If
would
there
have to
really-
be.
Yeah.
But
I'm just, why? Why would there?
if they require it, again, I don't know. Mr. Taylor will have to testify to this. I don't want to put words in his mouth, but it was,
I guess it's a.
he came back to us and said, we need parking. We drew parking.
Yeah, so if the answer is no determination has been made yet
Works
relative to whether it's a land development,
Yes.
then the gentleman's question, keep going, I didn't mean to interrupt.
So I just want to be absolutely clear. In your testimony to the board, you have actually no idea yet whether those 3 parking spaces that have been proposed would actually meet city requirements. It's a proposal at this stage.
I'm under the impression they would. I don't know if but none of this really has bearing on the immediate thing.
Are
Should we-
you answering for the record? You have to speak up.
Yeah.
I think he answered.
I answered. Okay.
This has immediate bearing on the request that you have made because the parking is the central aspect of the plan that has actually been proposed here. Did you look into the steep slope and drainage requirements about what happens if you move any earth in front of that property? Is that something you did as part of your research in planning parking in front of this house? Have you done that work yet?
Sir, this is only a schematic plan so far. We haven't
Sorry, can
fully
you just
designed.
speak into the microphone?
This is just a schematic plan right now. We haven't fully designed it yet.
So again, just to be clear, for the purpose of your testimony to the board, you do not know whether those parking spaces would be permitted.
No, I guess I don't.
Thank you.
Wouldn't that be on the city though to determine that and then re-bring it back? Like
No,
that's not
but to the point that, yeah.
right. Like that wouldn't be
It-
our determination is not to determine tonight whether those
Yeah,
parking
I don't want to
spaces.
deliberate in public. I mean, I'll give you legal guidance there, but and both attorneys can jump in. To the gentleman's point, if those parking spaces are not feasible and they need to modify something relative to it, if there's a zoning problem, then they'll have to address that then. We're here tonight solely on the special exception, the appeal on the use, and on the alternative relief for the variance.
And if I may, the alternate use rests in part on this parking proposal.
I get your point.
That's, I think, a
I just wanna make
determination
sure
for the
the-
zoning officer to make.
We get the point. All right. Any other questions to the public? Your redirect.
I have no redirect at this time. I will.
I always appreciate you. Okay. So, Attorney Rashidi, any other witnesses?
If Attorney Deshler's calling Mr. Taylor, I'll just wait. to
Oh, you made that point
cross-examine him.
earlier relative to that. Yeah.
If not, I will call Mr. Taylor.
I'll call Mr.
I can call him now.
I want to get Mr. Simonson done.
They're fighting over you, Dave.
All right.
Oh,
All right.
I'll call Mr. Taylor.
All right. I just would have Mr. Taylor as of cross then, and Mr. Simon says.
Okay.
I will respect your time and go. Matt, go.
Yeah, I guess I got it clear. I'm not sure this is working.
They're off tonight.
I've been pressing it.
No, there was
I
something.
tested it when I put it over there.
Yeah.
That's not, it wasn't me. I don't
No.
It's just, oh,
I think it's like flashing red.
Just this one. I'm gonna pull this over.
and- yeah.
Matt, how about he goes? Oh, there you go.
Want me to sit at the end here?
Can,
I can
or
move
can you even do it
myself.
from there? Yeah.
Oh, this is fine.
This one. Oh, but you need to show them exhibits, don't you?
I think I got a spare set.
Okay.
All those city exhibits you gave us before.
I'm gonna zoom that in.
Which ones specifically are the ones with you?
I think we're ready to go.
Sir, can you just state and spell your name, please?
I'm Mike Simonson, Simon as in Nancy, SON. Chief Code Official for the City of Bethlehem.
Next question. So you're employed by the city as the chief code official?
Yeah, I am employed by the City of Bethlehem as the Chief Code Official.
How long have you been employed by the city in that capacity?
Approximately 8 years.
Since 2000?
It's February of 2018.
Okay. And what are your duties as the chief code official for the city?
I oversee the Code Enforcement Bureau, and I also oversee the Housing Inspections Bureau.
And do you have familiarity with what we call regulated rental units?
Yes, I do.
And are you responsible for overseeing the administration, licensing, inspection of regulated rental units in the city?
Yes, I am.
How many individuals are subordinate to you in your position as the chief?
Between the two bureaus, probably about 20.
And these would include housing inspectors?
These include housing inspectors, housing administrative staff, and code enforcement inspectors and code enforcement staff.
Now, you're familiar with the property at 436 First Terrace, correct?
Yes.
And since I went over some of these before, Mike, let me see, do you have any objection to any of my exhibits being presented?
I don't.
All right, so I think I presented exhibits 1 through 25. I would just move those so that they're all into evidence.
So moved or so accepted.
Thank you. All right, so Mr. Simonson, you have your exhibit packet in front of you?
I do.
All right. How many times, just skip the first one, we've already kind of covered that, the NC Pub printout. So City Exhibit 2 is the photographs of the property. Have you been to the property?
I have.
How many times?
Personally, about 3 times.
Do you recall when those were?
I do not. It's been about 3 times throughout since probably 2020.
So 3 times after the current property owner purchased the property.
Correct.
And during those visits, were you able to inspect the property?
Personally, I was not. My inspection staff has.
So City Exhibit 3 is Article 1739. Now, is that the ordinance that governs, I'll say regulates, regulated rental unit occupancy in the city?
Yes, it is.
In fact, that's the title of the ordinance, right?
Correct.
And there's a definition for, and let me just say this, since you've been in the city, you've been at the city since 2017, has this ordinance been in place?
18, and yes, 2018.
And so since you started with the city in 2018, you've applied this ordinance?
I have.
And are you familiar with it?
Yes,
And are you familiar with the definition of regulated rental unit?
I am.
And if we look at page 4 of the article, are you there?
Yes.
And at section 20, it says a regulated rental unit, a dwelling unit occupied by 3 or more, but not more than 5 unrelated persons under one rental agreement. That's what it says, correct?
Correct.
And there's a notation there, ordinance 2017-15 passed May 2nd, 2017. Do you see that?
Yes, I do.
And that would have predated your employment with the city, correct?
Yes.
So since you've been employed by the city as a chief code official, the definition I've just read has remained the definition of a regulated rental unit, correct?
Yes.
Are there inspection regulations relating to regulated rental units?
Yes, there is.
Okay. And how frequently is an RRU, I'll call it, inspected?
Annually.
And if we look at the ordinance on page, give me a second. Page 10 of the ordinance, it's section 1739.04, titled Licenses and Inspection. Is that the section dealing with the frequency of inspections for RRUs?
Yes, it is.
And in terms of the frequency of the inspection, subsection or section B, where it says annual license fee and occupancy limit, is that where the city gets the authority to inspect an RRU every year?
Yes.
Okay, so you can put, oh, sorry, one more thing here. There's a section in the ordinance on page 6. So this will be 1739.02E, reading rental agreement. Do you see that?
Yes, I do.
For a regulated rental unit, is it required that there be an addendum attached to the lease?
Yes, there is.
And does this section provide for that addendum?
Yes.
And is the addendum itself actually attached to the ordinance on pages 19, 20, and 21?
Yes, it is.
And as part of this addendum, and does the addendum have to be attached to any lease for an RRU?
Yes.
And does the addendum have to identify a tenant of the property?
Yes, it does.
Now you can put City Exhibit 3, the ordinance aside. City Exhibit 20 is the next one in your packet. We went over that on my examination of Mr. Gliniani. This form, this notice that was signed by Austin Saboni dated October 30th, 2019. Is that in the city's housing records?
Yes.
As a chief
Yes.
official, do you have access to those records?
Yes, I do.
And would this record have been maintained in the ordinary course of business?
Yes, it is. Yes, it would have been.
And what is the significance of not checking the no box on the form?
This lets us know that the intent of the owner is to operate the property as a regulated rental ordinance. Regulated rental unit, I'm sorry.
I struggle with that too. So this form, would it have been sent out to the property owner by the city?
Yes.
And does sending out this form signify the city's belief that the property is an RRU?
No, this is just an intent to operate on behalf of the owner to operate it as a regulated rental unit.
And if the person gets the form, sends it back, and checks the no box, what does that mean?
Then it would split into two things. Two things could possibly happen. We would determine whether or not the owner had the intent to rent the property as a residential rental, or whether they were going to own or occupy it. So it would lead us to believe it was either going to be one of those two moving forward.
But if they check the no box, then the city classifies that as something other than an RRU.
Correct. Other than an RRU.
And City Exhibit 21, can you tell us what this is?
This is a field inspection report back from March 12th of 2020 for the sale of 436 First Terrace.
And so the date time on the right-hand side of the top is March 12th, 2020, correct?
Correct.
And there's an application date on the left-hand side, February 3rd, 2020. You see that?
Correct.
What's the significance of that date?
So the February 3rd, 2020 date is the date the applicant applied for this inspection. The 3/12/2020 was the date the date that I guess the applicant and the city agreed the appointment would be.
You said this is a field report?
Yes, this is a field report.
So this is when the inspector takes out to the property and makes kind of notes as he or she goes along with the inspection, right?
Yes.
But at the top of the page, there's information, let's say like above the line that begins provide smoke detector in. You see that?
Yes.
Like there's text above that line. When does that text get inserted?
That text is inserted on the application date of 2/3/2020. In this case, it was taken by whoever received this application for the inspection.
So the information above the line provide smoke detector in would have been put in there, written in there prior to the inspection date, correct?
Yes, yes.
And how is the information above that line received and documented?
That information is given to us from the applicant.
And the applicant here was Austin Saboni.
It looks well, Lehigh Properties. It was the applicant. It was requested by Austin.
Okay. And there's the line where it says remarks, 3 students, SFSDD. You see that?
Yes,
Who would have provided that information?
the applicant.
Would there be any reason for the city staff member filling out this form to assume that there would be students at the property?
No.
And City Exhibit 4, the next exhibit, just can you briefly go over what this is?
This is I'm sorry. This is a screenshot from our it's called Community Plus. It's our library for all of our activities that happen in the housing and the code enforcement department. And what this shows is this is the application when it was entered into our system, our internal system. It was entered on 2/26 of 2020. And it says here under it says the permit type. In this case, it's a sale of a property. As we noted, it was a sales inspection. And then and then we have a purpose special conditions, and then it says sale will be RRU 5 students, 3/12/2020, which was the scheduled inspection date. House is being renovated.
And that language you just read, who would have inputted that into the system?
We would have inputted into the system, but we would. The only thing that we would know is the inspection date. The other information would have to be provided to us.
So the language you just read, sale will be RRU 5 students, March 12th, 2020, house is being renovated. That would have been provided by the property owner.
Correct.
And when a property is conveyed, when a sale occurs, does the city by ordinance require a sales inspection?
Yes.
Now, it's supposed to happen prior to the sale or prior to the conveyance of the property.
Yes, the sales inspection is yes.
Does it always happen that way?
No, it does not.
Did it happen that way in this case?
No, it did not.
So it does happen where the sales inspection is actually performed after the sale of the property.
Yes.
So, and I think we saw in the field report that there was an inspection done on March 12th, 2020, right?
Yes.
And then after the inspector goes out and does the field report, is that reduced in a more formal final report?
Yes.
And if we turn to City Exhibit 5, what is that?
So this would be in 2020, what would be our more refined report. And this would go through the inspector's field notes and field report and comprehensively just add everything in a more user-friendly format.
And this sales report, City Exhibit 5 for the property at 436 First Terrace, there are a number of violations noted, correct?
Yes.
Would it be possible to issue a CO for the property, a certificate of occupancy for the property at this time with these violations?
No.
And just to be clear, on the second page of that exhibit, the bottom paragraph is, prior to transfer of ownership, the current owner of any dwelling unit or structures shall first furnish the grantee, transferee, mortgagee, or lessee a true copy of any compliance order or notice of violation issued by the code official, and shall furnish the code official a signed statement from the grantee. It goes on and on and on, right?
Mm-hmm. Correct.
But again, this signifies that the sales inspection is intended to be done prior to the transfer of the property, right?
Correct.
Put that aside. So when if ever does a property get lodged in the system as an RRU? Would it be after the applicant sent back or the property owner sent back that form that we looked at as City Exhibit 20?
Yes.
Okay. So you send back that form, the city records reflect that your property is an RRU?
Yes.
Do the records reflect that even if you don't have any people living in the property.
And yes.
And see Exhibit 9, the next exhibit in the packet.
Mhm.
This is a regulated rental package. You see that?
Yes.
To whom are these sent out to?
These are sent out to, so just to take a little step back is, if you go back to, one of the exhibits here, the screenshot, just so I could show you. There it is, Exhibit City 4. There's we there's a, it's not on here in this particular one, maybe it'll show up in one later, but when we change the use group to a RRU, it automatically, when we do our regulated rental packets, it automatically picks up all those RRUs in our system and automatically sends them a packet based upon what it's classified as.
Okay, so the packet that we're looking at, that's City Exhibit 9, this is a packet that would have been, or that is sent out to all properties that the city's system identifies as RRUs, correct?
Correct.
And in this packet, the second page of the packet, we have a form that says, or that among other things requires the property owner to list the number of dwelling units, number of occupants, and the names of tenants, correct?
Yes.
And then further on, in the last few pages of the exhibit, we see again that addendum to residential rental agreement that we saw at the end of the ordinance Article 1739.
Correct.
That was City Exhibit 9. The next exhibit in the packet, City Exhibit 6, we've already looked at this. This is a June 3rd, 2022 RRU inspection report, correct?
Yes.
Now, does this reflect the first time that the property at 436 First Terrace was inspected as an RRU?
Yes.
Now, why did the city inspect the property in 2022?
As part of its annual inspection program.
And a number of violations were detected?
Yes.
Based on this inspection report, was the city able to issue the property a CO in 2022?
No.
And would the city do the inspection in 2022 that we just saw, even if there was no one living in the property?
Yes.
Because the applicant had asked for the inspection.
Correct.
So City Exhibit 7, just tell us what this is.
This is another screenshot. This is, let me just take a quick look at this. This is a RRU inspection report or inspection setup. You can see it says purpose and use, permit type HRRU, which is a housing regulated rental unit. Purpose is RRU fees for 22, no inspection performed.
What's the significance of the RRU fees for 2022 no inspection?
There was no access to the property in 22. They didn't, or we didn't receive a regulated rental unit packet back.
In fact, the applicant did not correct the violations noted in that June 2022 inspection report, correct?
Correct.
So there's no further inspection performed in 2022,
Correct. Correct.
If there are violations noted in the report, does the city have to come back and re-inspect it? to make
Yeah.
sure-
Right. So the owner or property manager or responsible party would notify the city when the items are corrected, and then we would go back for a reinspection.
All right, so the next one in the packet, City Exhibit 26. What is this?
This is another permit issued in 23.
When you say permit issue, what do you mean by it?
Just the permit number. I apologize. That's just how we describe it. But every time we enter anything into our comprehensive library, this Community Plus, it's just issued a permit number.
And I see there's an applied date, May 22nd, 2023, correct?
Correct.
Right, and the purpose special conditions section, it says RRU fees for 2023, inspection July 5th, 2023 at 9 a.m., correct?
Correct.
Again, this is for the property at 436 First Terrace.
Yes.
And the continuing references in these screenshots to RRU, why do they keep appearing?
They're just notes for ourselves, and it's a permit type is where it comes into RRU, housing regulated rental property. So we just note it in the RRU because it's an annual, just so we capture that.
Once the RRU designation gets burrowed in the system, does it change?
It doesn't change unless we're notified of a change.
Like if the property owner wanted to use the property for some other use besides an RRU, correct?
Correct.
Right. Looking at the next exhibit, City Exhibit 8. Now I know City 26 referenced inspection July 5th, 2023. So is this the inspection report from that July 5th, 2023 date?
Yes.
And on this date, and is the housing inspector there, Tom Yanka, is he one of your housing inspectors?
Yes, he is.
So what does this report reflect?
That no access to the home was available at the time of the inspection. And then just that a property, obviously we couldn't do a clear certificate of occupancy since we couldn't get in.
Okay. And then the next exhibit, City 10, is this an application, a filled out application that we saw from the blank form earlier for a regulated rental unit?
Yes. Yes.
Part of the packet.
Yes, it is.
And I think it was testified to earlier that this was submitted, at least dated April 2nd, 2024, and submitted by the property owner's property manager, correct?
Yes, it appears so.
And when the city gets something like this, what does that trigger?
That would trigger us to reach out to the property management company or the person they put of record on here to set up an inspection.
So now we're into 2024. The next exhibit, City 22, another screenshot from Community Plus. What's reflected here?
This was in relation to the application, or not the application, I'm sorry, the regulated rental unit packet that was then entered into Community Plus a few days later. You can see 4/10/24, and it just represents that HRRU fees for 24 and then an inspection date.
That'd be June 18th, 2024 at 9 a.m.
Yes.
So if we look then at City Exhibit 11, the next exhibit in the packet, it's an inspection report dated June 19th, 2024, reflecting an inspection date of June 18th, 2024, correct?
Correct.
And again, we see lots of violations noted, correct?
Yes.
And a CO could not be issued at this time, right?
Correct.
So the next exhibit is City Exhibit 12.
Okay.
And it's a violation notice dated July 30th, 2024. What is this?
This was a notice of violation sent to the property owner, 436 First Terrace, for lack of inspection.
Inspection under the regulated rental ordinance, Article 1739.
Yes, this is, I'd say lack of inspection. Let me rephrase that. It's actually for not abating an inspection.
Now, we're sending a notice of violation, charging the property owner with violating Article 1739, right?
Correct.
So are we assuming at this point that the property is a regulated rental unit?
Yes.
And that assumption is based on what?
That earlier document where they elected not it's been typically put in our system as a regulated rental unit, so it continues to be processed as that. I'm sorry. It was put in our system as a regulated rental unit, so it continues to be processed like that.
Right. And the October 30th, 2019.
Yes, yes.
The applicant never told us it was anything other than, sorry, not the applicant, the property owner never told the city that was anything other than a regulated rental unit, correct?
Correct.
And we're still relying on that document from October 30th, 2019.
Correct.
So August 7th, 2024, at City Exhibit 13, the final notice citation pending is the title. Again, this is a notice charging the property at 436 First Terrace with violating Article 1739.04 because the inspection has not been abated, correct?
Yes, this was a follow-up or a second notice to the exhibit City 12.
And the next exhibit in the packet, for me, it's, City Exhibit 14, a letter dated or a notice dated, or I should say an inspection report dated October 8th, 2024. What is this?
This is a follow-up inspection related to the original June 18th 2024 inspection date, where we went out for a inspection and on a recheck on 10/7 of 24.
And again, based on this inspection report, was the property able to be issued a certificate of occupancy?
No.
And just, Mr. Simonson, on the second page of this exhibit, the hash mark, it says property cannot be rented until clear certificate of occupancy is issued. No clear CO since 2007. That reference to no clear CO since 2007. 2007, a significant date in the city's record keeping.
The records we have on this property only go back to 2007. We knew it was owner occupied prior to, so the reason we just, this statement was added of no clear CO since 2007 is because that's as far as our records went back at the time.
So City Exhibit 15, this is another inspection report dated November 27th, 2024, also referencing back, as we've seen before, the inspection date of June 18th, 2024. What is this document?
This is another inspection that we went out to the property on 11/25 of, it's an error on there. It says amended report 11/25 of 2021. It should actually be 2024. We went out there. And again, no changes. All the violations still remained.
And no CO could be issued for the property.
No CO could be issued.
So City Exhibit 16, what is this?
This is a this is a regulated rental unit packet that was sent in
By the property owner?
by the management company.
And I know it's not dated, but do we know when this was sent in?
It was sent
Look at
in.
City Exhibit 23, the next exhibit.
Yeah.
Shed light on.
Yes, it does. The application or apply date is 4/21 of 25.
And the notation there is HRRU fees 2025, correct?
Correct.
And City Exhibit 23 is another screenshot from Community Plus, correct?
Yes.
So the next exhibit, City Exhibit 17, an inspection report dated September 24th, 2025. What is that?
That was the inspection as a follow-up to the 2025 RRU packet submittal.
And what was the result of the inspection?
Property was not occupied, not habitable. We did not have access to the property.
And the next exhibit, City Exhibit 18. This looks like a form similar to what we saw earlier on where the property owner submitted back in 2019. This is an important notice for regulated rental units occupancy. Can you tell us what this document is, City 18?
Yeah, this is where we're sending out regulated rental notices, and the owner of the property at the time, it looks like signature is Francis Borso, notified us that the property was not being used as a rental property, that it was owner occupied.
What was the date of this form that was signed by Francis Borso?
September 14th, 2012.
And it reads, at the top where the no line is checked, right?
Yes,
So checking no signifies what?
that it is not a rental property.
And then the reason given reads, this is not a rental property. My mother, Mary A. Borso, owns and lives at 436 First Terrace, as she has since 1951. The tax and water bills are mailed to me because she cannot afford to pay them. So my two sisters and myself pay all her tax and water bills for her. That's what it says, correct?
Correct.
So as of 2012, did the city designate or classify this property as an owner-occupied property?
Yes.
And
What was that date?
September 14th, 2012.
Thank you.
And the designation of that property as an owner-occupied property, when would that have changed?
At the time of sale.
But at the time when the property owner sent back the form that's identified as City 20 on October 30th, 2019.
Yeah, that would have been a part of it. That also been, but they would have signed the sale inspection report from March, and it would have been transferred over in the system there too.
Okay, the sales inspection report though was from 2020.
Correct. But that would have came in first. The prior where they notified us that they intended to use it as a rental, regulated rental.
Mr. Simonson, just to address this issue, when the property owner applied or sought year after year to have the property inspected, did it pay the inspection fee?
Yes.
Did the city accept that fee?
Yes.
Why did the city accept the fee?
It was receiving the money to perform an inspection, and we performed the inspection.
Prior to accepting the application fee and performing the inspection, does the city do anything to confirm that a property that's represented by the owner to be an RRU actually has 3 to 5 unrelated people living there?
No, just the RRU packet.
Does the city accept the word of the property owner that if
Oh, yes.
let me finish, that if they're applying for an RRU inspection, they actually are an RRU?
Correct. Yes. Sorry.
Is there any reason why someone would pay a fee, seek to have an inspection for an RRU if they weren't trying to be an RRU?
No.
Would we have any reason to doubt them?
No.
In fact, in order to actually lease the property and have it occupied by 3 to 5 unrelated individuals, the property owner would need a passing inspection report, correct?
Correct.
It would need a clear CO.
Correct.
So in order to lease the property, let's say to students, 3 to 5 students, 436 First Terrace LLC would need to go through this process, correct?
Yes.
It is a prerequisite to leasing the property to students, right?
Yes.
That's all I have.
I will have some cross-examination. Thank you. Mr. Simonson, how do you determine which properties get sent registration forms for the regulated rental unit?
Which form are you talking about? Just so I'm clear.
Several of
The
them.
regulated rental packet.
The packet. How do they get the packet?
So
Yeah.
when we're notified that a property is an RRU, the packet is automatically sent to them every year.
Okay. So for Exhibit 20, City Exhibit 20, how did this get sent to Mr. Saboni?
This would have been sent to him in response to him telling us that he wanted to use the property as a regulated rental unit.
Okay. And when was that?
That was on February 3rd of 2020.
Okay. This is dated 10/30/2019.
I'm going off the inspection date. I apologize. Let me just see. It would have been, he must have bought the property prior to, well, yeah, we did clarify that. He bought the property prior to getting the sales inspection. So he would have been notified when he came in the office for the sale, and he probably we would have given him this form at the desk.
Okay. And now with regard to City Exhibit 21, who would have filled out the top of that form? Would that have been someone from my client or someone from the city of Bethlehem?
It probably would have been an administrative person at the city.
Okay. And you stated the information on there comes from the applicant?
Yes.
Okay. Now, how do you determine if a property gets removed as an RRU?
The owner would have to tell us that they intend to use it for something other than an RRU.
So if the inspection report indicates that it's vacant, you don't automatically remove it?
No.
Okay. Now, I did see on, let me just make sure I'm getting it, CE7.
7, you said?
Yes, City Exhibit 7. And I saw this on several other exhibits after this. The usage class. Can you explain that? So it's under permit details.
So under permit details, there's 2 types. Let me just see. I just want to make sure what I'm going to tell you is correct. So there is the permit type is our HRRU in this case. Are we on Exhibit 7? I just got to find it. Okay, oh, here it is. Okay.
Sorry.
I just want to make sure we're on the same exhibit. So R3, that designation of a usage class, that's an international code for, like, there's R1s, R2s, R3s, institutionals. It's a type of residential structure. That's more for us. It's a 1 or 2 family dwelling. That's what
And
that's.
then there's looks like under 5 unrelated. Is that what that means?
Yes, that's what it looks like.
Okay. And how would that have information been put in there?
That cross-referenced with the type of structure. So since it's a single family detached dwelling, it falls under an R3.
Looking at City Exhibit 13. Skipped over it. Sorry. Check that. City Exhibit 14. I'm sorry.
Okay.
And this is the inspection report from October 8th, 2024. And it may have been on City Exhibit 13. Open permits.
Yes.
Okay, when were those permits pulled? Looks like 4 open permits. Can you explain what they are for and when they were pulled?
I don't know. Well, I could just go off of what they say next to them as a description. So it looks like the first one on there, for example, 24060300, wiring for second floor addition. That appears to be a residential electrical permit. The first 2 numbers indicate the year the permit was pulled. So all 4 of these permits were pulled in 2024.
And generally, how long is a permit valid?
It depends. If work is stopped or not started for 180 days, it's void. But other than that, it can go on for up to 5 years.
Okay, so it looks like they pulled permits for wiring for a second floor addition, an interior alteration, HVAC system, and then another for an interior alteration.
Correct.
And you don't know what those are, what interior alterations?
Not without looking at the specific information.
Okay. When an applicant submits a permit, how does it go through review in the city?
So it depends on the type of permit. So Do you want me to just do like a residential interior alteration, for example?
That'll be fine.
Okay. So they would submit application along with drawings, permit, what we call a permit set. And then that permit set would then go to the several different departments throughout the city. So it would go through obviously code enforcement to make sure that it met all the code standards. It would then go through engineering, zoning, planning, all the subsequent bureaus that sign off on the permit for to make sure that it's can properly be issued.
So when the applicant applied to add the second story addition, it went through a review at some point,
It would have started the review process, yes.
and at that point, would zoning have indicated that it needed some sort of zoning relief in this case?
It goes through various departments at first, so I don't know if they would have necessarily received the permit application first, but they would have received it somewhere in that chain.
And it's probably a question more appropriate for Mr. Taylor, and I'll ask him, but did the second story addition initially determine that, did the city initially determine that it needed a special exception relief?
I wouldn't be able to answer that question.
It's a zoning question, correct?
Yeah.
All right, just want to make sure.
Yep.
Now, one second. I presented some exhibits on my side of the case, which I just have some questions about. At what point does the city, I'm going to show you two exhibits. They're exhibits 9 and 10.
I didn't get that packet. Okay.
At what point would the city have sought legal action in the district court for violations of the regulated rental unit ordinance?
These are in response to the January 20, the July and January were in response to, I'm sorry, they were in response to city exhibits 12 and 13. They were the notice of violation and then a final citation pending.
So when the city issues a violation pending, what kind of investigation do they do?
So initially, what we would send out is a notice of violation. The violation citation pending, would we go out for a recheck or an additional follow-up on that first notice of violation? And if we didn't see any action, a lot of times we'll see action when we send that second notice out, then we'll go to the citation. If we see the action required or the repair or whatever we need from the citation pending, we will not file the citation.
So, and these were the violations in this case, I just want to make sure I'm understanding, were having a regulated rental unit inspection or license, correct?
Not having, no, it's inspection performed, not having a certificate of occupancy.
And I'm just looking at exhibit 13.
If you look at 13, if you look at the bottom, it says inspection performed on 6/18 of 24.
Okay.
And that's where we get that from.
Okay. Would there have been a violation actually if there was no pending rental?
It's still part of the ordinance that it has to have licensed and inspected with a clear CO every year.
Okay. And in this case, at this point, this was 3 or 4 years into the ownership of the property by my clients. Is that correct?
Correct.
Okay. And at that point, have they ever passed an inspection?
No.
Okay. So why was there ever a citation issued previously?
Not to my knowledge.
Why not?
What we did in 2024 was went around and looked at all of the property, the regulated rental units, and sent out citation. We did a comprehensive thing. I think not just 436 First Terrace, but all the properties that had outstanding COs were were sent notices of violation.
Okay. And at any time, did you go to this hearing?
I did not.
Okay. At any time, was it ever asserted that to the owner that they really weren't a regulated rental unit?
I did not.
The city never asserted that?
No.
Okay. And just to clarify, the city took a regulated rental license inspection fee every year from them from 2020 to 2025?
22 to 25.
I believe there's one in 21 too.
Okay. Yeah. Then yes. Yes.
All right. And at any time did the they did they get an inspection every year?
With the exception of 21, we didn't do inspections that year because of COVID.
Okay. You didn't do them in and there, you're getting to my point here. In 2020 there was no inspections done either, correct?
The sales inspection took
Prior to COVID.
with the sale inspections good for 1 year. So that would have taken care of their the sales inspection in 19 through 20 would have taken care of 20.
All right. I just wanted to clarify that.
Yeah,
Just wanted to
yeah.
make sure. So basically every year of ownership, they had some sort of inspection done.
Correct.
Okay. Just want to put
Yeah,
that-
yeah.
But inspections weren't done in 2021 because of COVID.
Correct.
Okay. That wasn't clear on the record. I just want to make sure that it was clear, put on the record that there was not. All right. I think the rest of my questions will relate to zoning, so I'll wait to Mr. Taylor.
I have a bunch of questions.
Can I go now or after the board is done? Redirect.
Yeah, after kind of like what we did with him.
Maybe go after.
After you go through the audience, you do your redirect through done in one fell swoop.
So is this property designated as an RRU today?
It's classified as an RRU, but it doesn't qualify as an RRU. It's listed as an RRU because, like we said, that's what the owner told us it was. But
Mhm.
it doesn't meet the requirements of a clear certificate of occupancy and a paid inspection.
So does an inspection and a CO, like if they went through and they did everything that you guys said they needed to do and they got the CO, it would qualify as an RRU?
It would have.
It would have.
It would have.
Okay. So what is it categorized as today then?
It's still categorized as an RRU, but it doesn't meet the requirements.
Mhm.
So it would have to be reclassified.
To be what then?
It could be either owner occupied or just a what we call a residential rental, which is a rental available to a family.
Okay. So if you take this student housing aspect out of it, they could still in this district do the repairs that were needed and get it classified as an RRU.
No,
No.
not as an RRU because it's outside of the student housing overlay.
Okay.
So they could if they were to get the inspections and get a clear CO, they could operate it as a rental inspection.
But not as an RRU.
To be fair, that's kind of the question we're here for tonight. Is
Yeah.
Yes.
Right.
Did they? He keeps using the word. Attorney Raschuti keeps saying, was it a vested, non-conforming use?
Yeah.
That's kind of the inherent question.
I guess and I asked this, it could be a question for Mr. Taylor. Like I'm having trouble with like an RRU and a student housing. Like those are pretty similar definitions to me. It's just like whether they have a real job or whether they're 18 years old and they work, right? But or they go to school. So like in the city stance, you would say no matter what at this point, you're outside of that zone. So they couldn't have 3 to 5 occupants in this house, even if they're not students.
No, since they didn't keep up with their regular COs annually, then they're outside the zone. So no, they wouldn't be able to.
Even though you guys did an inspection every year as an RRU.
Correct. But it didn't pass any of the inspections.
Sure. And I think that's what the, the argument is. But so at any point when this new definition of student housing came to be, when was that? 21?
21.
Were buildings that were classified as an RRU, did you have to reclassify them as student housing?
No, they automatically folded into the student housing.
So that would be the vested
Yes.
interest.
I'm gonna object.
Yeah, I know.
And Mr. Simonson isn't really, he's not the zoning officer, and I think all this is kind of legal conclusion. I don't want to kind of confuse the record, right? Because there will be some, I think, very specific parsing about how RRUs are different from student homes and
Okay.
what's non-conforming use and things like that.
All right, so I'll take all that out. So I guess, I guess that answers it. So no matter what today, they could not come back and say, we're not going to come in as a student housing. We're going to get this classified as an RRU. And maybe that's a question for David, but that's off the table as well. In the city's eyes, you would not let them classify this as an RRU, even if they went through, passed the inspections and did the work. Like, when was that cutoff then? Because it looks like, in my mind, kind of what their argument is you guys took the payment 4 years in a row, and now suddenly we're saying you can't do that, right? Did something happen in 24 after that inspection that it's just like, okay, no more, like, we're not going to inspect this as an RRU? You know what I'm asking?
Yeah,
Like,
I do.
okay.
So it was more of we took the hard line that anybody who didn't have we went after everybody who didn't have a CO. It was starting to add up.
Gotcha.
COVID kind of knocked things around a little bit, so we were trying to play catch up a little bit and get everybody a CO. What the change is that where we stopped new student housing or new RRUs, whatever the definition is, for my purposes, just from the 1739 was when the student housing overlay came in. It was capped. Anything out,
Which was 21.
yes,
But you did inspections on it as an RRU post 21,
Right.
right?
right. But we go every year into the thinking that they're going to pass the inspection. You know what I mean? If they would have honored that and we would have passed it, they probably would be, but they didn't.
But when did that cutoff happen though? Like, that's what I'm trying to, like, when does the city go like, okay, you failed 3, or you never came back on 3 inspections, like you did it in 21, 22, 23, and then suddenly it's just like, well, no, now we're not going to do this anymore. Like, when was that determination made that and I get that they
You kept
failed,
going back and doing inspections.
right? Like, you
Correct.
kept going back saying, this is fine as an RRU, this is fine as an RRU, this is fine as an RRU. And now you're saying, wait, you're outside of the city, you're outside of the ordinance. Like, when was that determination made that, like, no, you can no longer get this inspected as an RRU?
Well, the determination would have been made sooner had the property been occupied.
Mhm.
So the property stood vacant. So it wasn't, you know what I mean? It wasn't it wasn't on our radar, high on our radar because it was vacant.
Okay.
But like I said, because it never had passed an inspection. So we were kind of just sitting on it. So in 24 is when we took that hard line and said, no.
Because it became vacant at that point, because the woman, I'm forgetting her name, was
yes.
no longer there.
Yes.
Okay. All right. I think I'm good. Thank you.
Good. I have one just clarification
Sure.
on your City 17 exhibit. Did you say that you didn't have access to the house to do the inspection in 25?
Yes. Yes, that's what we do. So either no one met us there, or someone, you know what I mean? We didn't have access
Thank
to
you
it.
for clarifying.
Yeah.
Yeah, maybe this isn't your question, but what is the difference between student housing and an RRU?
That's kind of a Dave question.
Okay. In your mind, though, is
Would you
there a
say,
difference?
or would
I would. I mean, I read the definitions before questioning Mr. Vignani. I mean, if I were to say student housing is kind of a subset of RRUs, but I think it's probably more legal argument.
So like all student housing's an RRU, but not.
I think the board's trying to understand the city's position about that distinction that was taken relative to this application.
Like he's going in to inspect an RRU, but he's really inspecting student housing? Or do you just on your forms you have RRU? Are student housings listed as RRUs on your forms? Like do you have a distinction on how you classify those two things?
No, the 1739 is what we inspect off of. The ordinance 1739. It's titled regulated rental units. That's why it's on our form. So we tackle all the I shouldn't say tackle, but we inspect all the regulated rental units and any subset of that regulated rental units the same.
Okay, so student housing is a subset.
Yeah, and there's no different there's no difference in the inspection standard or.
I represent the legal position. It's a subset in the sense that there's an added requirement for a student home beyond a regulated rental. They are different uses. It's just that everything that's student home would also be qualified as a regulated rental use. But they are different uses because the student home has the added requirement that there be students in there.
So every student home is an RRU, but not every RRU is a student home.
Well, I think from Mr. Simon's perspective, enforcing what is not a zoning ordinance, Article 1739,
Mhm.
that would be correct, that all student homes are RRUs.
Mhm.
From a zoning perspective, it's a little bit different because they are different uses.
Mm-hmm. Okay.
You anything else?
No, I think I'm good.
I just want to go back to, and again, if this is legal, then just tell me this is legal. They were found guilty of a criminal, at least twice, of a criminal offense under section 173904 C413. That was for failure to correct the defects identified in the previous inspection report.
Correct. Failure to obtain the certificate of occupancy. Failure to obtain the certificate of occupancy.
But that is specific to the RRU, or that was otherwise required for the disabled woman that was living in the
It would be required for either the rental or the RRU.
That was just, she didn't have a CO, someone's
Yes.
in that building. Thank you. But I'm sorry, is that a 173904? That's the RRU.
That's RRU. We cited out of the RRU ordinance for the lack of CO. It's 173904, right?
So that's not just for this, that's not the single occupancy, that's the RRU, that's
No.
the RRU one.
Correct.
But you had to pick one, and that's why
Correct.
it's there. That's all I have. All right, so public. Questions for the code official on the public? We love shaped heads at this point. Okay. So you want to redirect?
Yes. All right. So, Mr. Simonson, you are not the zoning officer of this, correct?
I am not.
You don't enforce the zoning ordinance.
I do not.
Article 1739 is not a zoning ordinance, right?
No.
So for purposes of Article 1739, for you as the code official, does 1739 treat regulated rental units differently from student homes?
No.
So for you, with your code official hat, they're one and the same.
Correct.
And I guess in that C plus system we've been looking at, all those screenshots, is there any kind of, I mean, there's an RRU designation. Is there a student home designation?
I don't believe so.
Not for the housing.
Not for the housing inspectors, no.
Right, and the violations that we saw, the convictions that are exhibit 9, the applicant exhibit 9. Right, so one of the violations was Article 1739.04 C413. So Mr. Simonson, that would be this here where it says, and this is from Article 1739, read it together. All premises shall be subject to periodic inspection by the code official.
Sorry, Matt.
All premises shall be subject to periodic inspection by the code official or other duly authorized agent of the city as outlined in section 1739.04 B.4.9. Such inspection may take place when an application is submitted for a license or at any time during the year. The fee for inspections are contained in Article 1731 of the codified ordinances of the city of Bethlehem, section 1731.02. That's correct? Correct. And that was, and the applicant or the property owner was being cited for that because of the failure to abate a prior inspection.
Correct.
And the other violation, which was a conviction on, that's exhibit 10, applicant exhibit 10.
Can we ask how?
The violation notice is, or the convicted violation is 1739.02 A2.1, right? And that section is
Okay.
right. So A2.1 is, it shall be the duty of every owner to keep and maintain all regulated rental units in compliance with all applicable codes and provisions of all other applicable state laws and regulations and local ordinances, and to keep such property in good and safe condition, correct?
Correct.
So we saw those inspection reports. Was the property kept in good and safe condition?
No.
And Mr. Simonson, I know you're not the city zoning officer. Are you familiar with the concept or doctrine of a non-conforming use?
Yes. Yes.
Are you familiar or do you know that the student home overlay amendment was adopted in March of 2021?
Yes, I'm aware.
Right, so in October of 2019, and let me just say this, because of the overlay amendment, if you have an RRU or a student home outside the overlay or other permitted districts, your student home or RRU is not a permitted use, correct?
Can you repeat that one more time?
If you have a student home outside the overlay district, and there are some other districts where it's permitted, but not in the RT, you can't put a student home or an RRU in the RT, correct?
Correct.
All right, so, but in 2019, we didn't have a definition for student home, right?
We did not.
We did have RRUs, correct?
We did.
Right. So if someone had established an RRU as a lawful use in 2019, could they have continued it after the adoption of the student home overlay amendment in 2021?
Yes.
So and in 2019, the property owner represented their property as being an RRU, correct?
Yes.
So as we continue to process these inspections year after year, were you looking back at the 2019 representation?
Yes.
That's all I have.
Anything else? I don't have any questions.
All right. So I'd like to, for just a moment, to go off the record and recess if we can, because I think we have to have a conversation relative to the hour. So with the board's permission, can we go off the record?
You can go off the record.
All right.
Phone's coming back up.
And Austin next time, I'm assuming.
All right, so I'm just going to announce on behalf of the board that this matter, sorry, I'm just going to make an announcement on behalf of the board that this matter is being tabled for this evening, that it'll be rescheduled for the evening of March 25th, reconvene at 6:00 p.m. Attorney Raschuti, does the applicant waive any applicable time periods in the municipality's planning code as required for the scheduling of the hearing that night?
We waive any requirements.
Thank you, sir. And with that, this matter's tabled. We thank you. Oh, sorry, sir.
My exhibits, I
You just want to move it? You want to,
17, if I can just move them for admission.
and
All right.
there, so admit it.
18, I never put in. It's in your
And let me
package.
do my last housekeeping item because I'll forget. I'm going to mark the application as ZHB 1.
Okay,
I'm going to mark the letter as ZHB 2 solely for identification,
sounds good.
not for admission. The objection was sustained. Thank you, gentlemen.
Yeah, he'll testify about it, so.
All right.
All right.
All right.
Next
Next up.
appeal, 622 Ridge Street.
Okay.
Mr. Taylor, if you read the back.
622 Ridge.
Yes.
Sorry.
Yes.
620 622 Ridge Street, applicant of Robert Dandy for dimensional variances to permit a 3-story, two-family detached dwelling where the zoning ordinance only permits a maximum of 2.5 stories. Sections 302.54, 1306, 1302.54, 1306.01A4, 1325.06, and all associated variances, special exceptions, and interpretations. This project received a parking variance via written decision dated November 26, 2025.
Thanks, Steve.
What's that?
So I'm Robert Dandy. I don't know. You tell me what you want.
So, sir, when was the property posted?
Properties posted January 20th.
Good. Go, Mr. Dandy.
This is really kind of a housekeeping item that happened by default. We got a variance approved to put buildings back on. All of you were here, in fact, and the lady who left was very helpful also. It was a shame. But anyway, so we got various variances to put back basically twin structures that were on the property that have fallen into disrepair, were raised and such many years ago, and such. With that being the case, we came to find, after we got the variance approved, that the building plan that we had proposed, that we were thinking of, was 3 stories, and it was presented as 3 stories at that time. However, in looking diligently at the variance approval afterwards, we came to find that because of the slope, that technically the basement counted as a story, as opposed to the 3 stories that would be for living purposes. And so as a result, we came back to tweak the variance approval to get a full 3-story, thank you, Dave, to get the full 3 stories approved that we need in order to not cramp down the hardship, is in effect that the 3rd story would have a bedroom all by itself, and that's really not a typical floor plan at this point in time.
So, sir, can I make this quick then?
Sure.
Can the board incorporate by reference the findings of fact issued in its prior decision?
Yes.
Have you modified the proposal in any way, or is this the same proposal just with a new calculation relative to the height?
It's the same proposal, but with a new calculation relative to the height. And by reference, unless Dave, I'm wrong in that, but I think that's the case. By reference, there is exactly the same floor plan and height and slope considerations right across the street on Ridge for a variety of homes. I think Dave could pull up for us. The homologs are there, and all of the garages on that side are in the back. So from that perspective, so really we're just looking to mirror what's there and such, but it's really a calculation that we had not anticipated given all the things we were doing in our last variance. So in effect, we're asking for permission to go from 2.5 stories to 3.
Based solely off of the fact that the calculation changed relative to grade.
Great.
Yes, the grade had, as we calculated, and primarily because we moved, I think sagaciously, the building closer to the road, the grade then steepened, and we got the basement being counted as a floor that I don't think any of us anticipated back when we went for the variance approval back in November.
Any questions from the board?
So it's the same floor plan.
It's the same. Yeah.
There's no change.
Oh, all right.
There's no change, and the change really happened by default by moving the property closer to the street, as was suggested.
As we requested.
Yeah,
All right.
everybody here was here at that time. I mean, I know a lot goes on, but
A wise man told me to sit down and stop talking when you're winning.
yes, sir.
Okay.
Are we? Do you need to go off the record? Everyone remembers.
Yes, I remember very clearly.
That-
Oh, please.
Can I have a motion from a member of the board?
I will approve.
Motion
I
to
make
approve.
a
Motion to approve.
I heard a second.
Second, yes.
Mr. Schneck,
Yes.
Ms. Wiles Young,
Yes.
Mr. Wolk.
Yes.
Motion carries unanimously, 3-0.
All right.
Thank you.
Adjourned.
Have a good night, all.
Thanks
Thank
for your
them because
patience.
there's the anniversary. He came back in a month.
Yeah, thank you for.
Thank
yeah.
her because
Yeah.
yes.
Yes.
Have a good night.
Well,